Welcome members. This is the 13th meeting of the Committee for Justice. The meeting is now open to the public, so we'll allow folks to come in for a few seconds. Just to remind you members that the committee will be recorded and broadcast throughout Parliament buildings and online. We're all welcome to use mobile devices, but they need to be in airplane mode and muted. So we have Keir Ferguson and Maurice Bradley remotely. We're also expecting Sinead Ennis remotely. And there's Sinead joined us, thank you. Sinead, you can hear us okay?
Yes, Chair, I can hear you.
Great, thank you. Members, it's proposed that the oral evidence session with the Public Prosecution Service and the oral evidence session with departmental officials on the budget and June monitoring round will be recorded by Hansard. Are members content?
Agreed.
Thank you. We're all obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to matters under consideration. We're supposed to do that either at the start of the meeting or in advance of the relevant item. Does anybody have anything they would wish to declare? Could I record that I have an immediate family member who works in the legal profession, please?
Sister in the court service, so just pertaining to the budget discussion.
Thank you. Can I also welcome Niamh McAvoy to the Public Gallery? Niamh's a committee specialist from the UK Parliament's Joint Committee on Human Rights, and she's going to be supporting the Committee for Justice in June and July during the dissolution period. She's going to be working with the Assembly's Research and Information Service on the Committee's request for information around mental health issues within the criminal justice system, and she'll also be contributing to a paper for the forthcoming Justice Bill. Niamh, you're very welcome, and thank you very much for helping out. We hope that you enjoy your time with us here. Thank you. Agenda item 1 is apologies. I have apologies from Alex Easton. Do we have any other apologies? Thank you. See, Justin has joined us and I know he's en route here. Agenda item 2 is the draft minutes of the meeting held on the 30th of May, which are at pages 5 to 14 of your pack. Are members content that those minutes are a true and accurate reflection of the proceedings of that meeting? Yes, and I'll sign them. That's lovely. Thank you. Agenda item 3 is matters arising. We have none. I presume nobody else does either. Thank you. And agenda item 4 takes us to oral evidence from the Public Prosecution Service for Northern Ireland. The appropriate papers are found at pages 16 to 21 of your packs. So we'll just allow them to get settled.
Hello.
Hello.
Members, we're being joined by Stephen Heron, who is the Director of the Public Prosecution Service. We have Michael Agnew, the Deputy Director, Marianne O'Kane, the Senior Assistant Director of Serious Crimes and Regions, and Peter Lunny, the Senior Assistant Director of Resources and Change. Peter, can I just check, is it Lunny or Looney?
Looney.
Looney, thank you very much. I'd rather get it right and take the time to check. Thank you. So you're very welcome. Thank you very much for taking the time to come and join with us today and give us a briefing. We look forward to hearing what you have to say. I will hand over to you to give your presentation and then there'll be some questions at the end. All right. Thank you very much.
Yes, thank you very much, Chair, and to the committee for the opportunity to speak to you today. We always appreciate interest being taken in the work of the PPS to help inform understanding of our complex and sometimes misunderstood role as prosecutors. So I do have a brief presentation, Chair. I thought it might be helpful to briefly address some key issues under the headings of Constitution, Conduct, Capacity and Challenge. And you've kindly done the introductions for me with the rest of the team. So this is the entire top team of the PPS, although we'll have leaders at many different areas of the organisation. I thought I'd bring everybody here today so they can share my pain and also meet you all, and hopefully in the future it'll be good contact points if you do have ongoing engagement with us in the organisation. So Constitution, I'll not dwell on a history lesson, but the Office of the DPP was established in 1972, and at that stage we discharged our functions under the superintendence of the Attorney General, who wasn't a local Attorney General then, it was the Attorney General for England and Wales. And all of that changed following the signing of the Good Friday or Belfast Agreement and the Criminal Justice Review that then followed in 2000. And that review recommended the formation of a new Public Prosecution Service to replace the DPP, and the PPS then became operational in June 2005, so it'll be 20 years old this time next year. The PPS took over the prosecution of all less serious offences from police, and in keeping with the Criminal Justice Review recommendation that it was critical that the PPS was completely independent from the executive, the relationship with the Attorney General was put on a consultative footing rather than superintendence as it had been previously. So our system here is perhaps most like that in England and Wales, and yet there are some key differences. The Crown Prosecution Service, established in 1985, never took over the prosecution of all offences from police, and responsibility for some minor offences always remained with them. Offences which can be prosecuted by police without reference to the CPS have increased quite significantly over recent years, and these are known as police-led prosecutions. So, unlike the CPS, the PPS receives all files from police which contain a no prosecution recommendation. And the basis on which PSNI have been operating to date is to submit a file to us where evidence exists, however weak, that an identifiable person has committed a criminal offence. However, the CPS guidance makes clear that police can decide not to submit a file if the evidence is not considered to meet the test for prosecution and it cannot be strengthened by further investigation. So this chair explains why there are more no prosecution decisions taken by the PPS when compared to the CPS, as the evidentially weak cases are not submitted for a prosecution decision in the first instance. Finally, I personally take decisions here which are exercised by the Attorney General in England and Wales, and most notably perhaps is whether or not to refer a sentence to the Court of Appeal on the grounds that it may be unduly lenient. And uniquely to this jurisdiction, I can also issue a certificate for non-jury trial if I consider that the statutory criteria for doing so is met. So just briefly, when comparing the PPS to the DPP's office in the Republic of Ireland, the primary distinctions are that in Ireland, the decision making in relation to the majority of decisions to initiate summary criminal proceedings are made by an Garda Síochána without reference to the DPP, and then police present those cases at court. And in February this year, a high-level review group commissioned to look at whether the DPP should take over those conduct of those prosecutions from police recommended against this, and the cost of same was cited as a significant factor, and that might be an issue we return to when we talk about a proportionate approach and reducing demand on the criminal justice system. And finally, on this piece, Chair, as DPP I perform a quasi-judicial function in deciding whether or not to prosecute, and in that regard maybe have more in common with a judicial appointment rather than a political one, and that explains why Michael and I were actually not civil servants, but were public appointments made directly by the Attorney General, and she can also decide to remove us from office, so she's a person I keep in good favour with. And on that note, I'm similarly constrained as a judiciary in not being able to discuss individual cases for reasons I've previously set out to the committee in correspondence I think you have dated June 2021, prior to my last appearance. And as I indicated at that time, entirely happy, more than happy to appear perhaps twice a year if that would be of benefit to the committee to discuss policy, practice and general performance issues. And my staff and I are always amenable to assisting the committee in deliberations on legislation where that's appropriate. So in conduct, I recognise that it can sometimes be suggested that the PPS applies different rules to different cases, perhaps depending on who the victim is or indeed the reported suspect. And sometimes, indeed, such criticism can be contradictory depending on the political or social viewpoint of the parties concerned. And legacy cases are one such example, where there have been some voices suggesting that the PPS is involved in a concerted effort to pursue former veterans for prosecution, while others, on the other hand, would suggest that the PPS is reluctant to prosecute current or former state actors. And I can assure you, Chair, categorically that neither proposition is true, and the PPS approaches legacy matters and all other offence types entirely impartially and objectively. All decisions are taken in accordance with the test for prosecution set out in the PPS Code for Prosecutors. In fact, prosecutors are duty bound to act independently, and this is enshrined in the legislation underpinning the PPS. An often misunderstood aspect of the prosecutor's role is that we must act in the interest of justice and that we are not the personal legal representative of a victim. But that independence and impartiality does not mean that we do not feel compassion for victims and indeed on occasion defendants who often come before us from very troubled and difficult backgrounds. However, we must ensure that we leave any emotion or personal feelings out of decision making and apply the principles set out in the code and prosecutorial guidance without fear or favour in every case. To do otherwise would simply lead to inconsistency and legally unsound decisions, which would greatly erode public confidence. And of course, this can be challenging for us when there's a deep desire by an individual, political groupings, or even large sections of society to prosecute a particular case, and our decision is that the test for prosecution is not met. And obviously, in such cases, we will take careful consideration of all the evidence and the advices from senior counsel. But ultimately, it falls to us to make a call based on not whether it will be a popular decision, but rather is it the legally correct decision. And indeed, as director, I've had it suggested to me on more than one occasion, is it not just easier just to prosecute evidentially weak cases, let someone have their day in court, and if a case is unsuccessful, that's a better outcome to deal with than having to deal with not prosecuting at all. But in short, that would be a complete dereliction of any prosecutor's duty and something we wouldn't countenance. So capacity then, PPS is demand-led, but typically we take around 50,000 prosecution decisions a year. And thanks to the hard work and commitment of PPS staff and the council we engage, inspections of our work have generally found the quality of decision making to be very high. In the Crown Court, we usually have a conviction rate around the 86% mark, and the Magistrates Court about 80%. However, where we and other criminal justice organisations undoubtedly need to improve is in the timeliness of case progression from investigation through to disposal at court. Over the last 10 years or so, there have been a number of pressures that have stretched the capacity of the PPS, and our resourcing has not kept pace with demand. While I appreciate there are, of course, significant financial pressures right across the civil service on many public services, demands on the justice system here have perhaps not received as much attention as they should have, and indeed as they have done in other jurisdictions, where additional funding has been allocated. As regards capacity pressures on the PPS in particular, I would outline a few key factors. Firstly, overall, the number of more serious files being referred to the PPS, which usually result in Crown Court prosecution, has increased by around 30% in the last 10 years. Within this increase in caseload, the number of serious sexual offences coming to us has increased by over 50%, and that's around the same increase in domestic violence cases, although they are more often prosecuted in the Magistrates Court than the lower court.
50%, did you say that?
Yes, it's around 50% share for sexual offences and domestic violence cases. In fact, I think the latest stats we had, and Marianne might touch on this later, it's about a fifth of our caseload now involves potential domestic violence offences, largely new to the new legislation as well coming through. And it's an upward trend that's steadily been rising year on year and shows little signs of reversing. Secondly, it's widely recognised that prosecutions involving domestic and sexual violence are often evidentially difficult and have higher attrition rates in comparison to other offence types. There is a low rate of guilty pleas being entered in these offences, either at an early stage or at all. And the PPS collaborates with many partner agencies who do crucial work to support victims, but the reality is there's an additional cost of prosecuting these increased numbers of sexual and domestic violence cases through to a contested trial. Thirdly, these cases are also more resource intensive to deal with due to the type of material that has to be processed, either for evidential use or for disclosure to the defence. There are often large amounts of what's called third-party material, like medical records, counselling notes, which have to be considered. There's also been an exponential increase in the amount of digital material requiring review, including CCTV and body-worn camera footage, mobile phone data, and material from social media activity. So we're currently working with police on a joint strategy for investigating and prosecuting serious sexual offences, with assistance from the joint lead of the Ministry of Justice end-to-end rape review, which was conducted in England and Wales a couple of years ago. However, Chair, my concern is the strategy will achieve nothing if it's not suitably resourced, and funding has been made available in other jurisdictions where they've had similar strategies and have implemented them. And when Sir John Gillan completed his review into serious sexual offending here in 2018, he recognised the need for additional criminal justice funding to implement his recommendations. Simply put, this additional funding has not been made available in recent years, and the PPS budget has not kept up with increased levels of demand and the impact of new legislation to tackle coercive and controlling behaviour, stalking and non-fatal strangulation, and this has resulted in increases in delay. And I think, Chair, that's unfair not only to victims, increases their trauma, but it's having a significant detrimental impact on PPS staff for whom workloads have become intolerable. And due to the lack of a sustainable multi-year budget, we have been reliant on monitoring rounds to make ends meet and have not been able to staff up to full capacity, with reliance on agency staff to make up at times around about 20% of our workforce. This year, through close working with our funders in the Department of Finance and direct engagement with the Finance Minister, which has been of great benefit, we have a settlement which has narrowed the budget deficit that we face annually. However, further funding in recognition of the increase in demand I have outlined is crucial if we're going to be able to begin to tackle long-standing issues around delay and also be in a position to modernise our service. And this is something I'm quite passionate about, and I'm sure we'll come on to discuss in the course of today's session. And finally, Chair, on challenge, I have to say I am dismayed when I hear accusations that the PPS is not accountable and there perhaps needs to be some review of our independence. It is true that the PPS is by deliberate design independent from political and executive oversight. I'm not directly operationally accountable to the Minister, Justice or any other Minister, or the Attorney General, and the PPS is a non-ministerial department and not part of the Department of Justice, as is sometimes not fully appreciated. However, I am fully accountable to the rule of law, due process and ultimately the public, and decisions to prosecute are robustly tested at court. When we decide not to prosecute, we provide reasons to the complainant and sometimes also publicly if it is a high-profile case of wider public interest. And these decisions can firstly be reviewed internally and then, of course, by judicial review. I am always conscious that our independence can sometimes result in unintended isolation, and this is something I am keen to address, in particular is how we are viewed by politicians. So I've written to the Executive Office and all the main political parties, inviting engagement with us to see what we can do together to improve outcomes and maximise public confidence in our criminal justice system. And I think all of this can be done in a way that doesn't impinge at all on our statutory independence. Now, I do realise there's an election coming up, and that might be why I've not yet heard from all parties concerning my invitation to meet with them, but I can tell you that the offer is genuine and remains open. We're not an organisation that thinks itself immune from criticism, and we will always seek to respond appropriately to legitimate concerns. But I sincerely hope that we can use today to start conversations about how we can balance the political challenge of our independence with perhaps finding some political champions for it. So thank you, Chair, for the opportunity to make those remarks, and we're happy to take any questions you might have.
Stephen, thank you very much. I'm going to open the floor to members first, as usual. Stuart.
Right. Thank you for that. That's been a very useful background and help to us. And I very much appreciate your comments around how you act in both an impartial manner in terms of your approach to the evidence that is brought to you and the way in which you make your prosecution decisions. You made reference to the code of practice for prosecutors. Does the code of practice in Northern Ireland mirror the code of practice for the Crown Prosecution Service and the rest of the UK?
Yes, it would be similar. The test for prosecution is slightly different. We look for evidence that provides a reasonable prospect of conviction, and their test would say realistic prospect of conviction. There's probably been many articles written on whether there's a practical difference between the two tests. In reality, not. But we are very similar in how we operate to England and Wales. So there would be many common features between the code there and our code. Very different, though, to Scotland, and probably next resemblances to the Republic of Ireland.
And you also made reference to quite often how the public view the prosecution service, particularly if you're a victim. Many victims will see the prosecution service wrongly, I appreciate, as their legal representative in court. And that causes a lot of distress and concern for people in respect of the lack of what might be seen as engagement with lawyers and others in presenting a case. Of course, people who have been a victim want to be involved quite often in the minutiae of their case. And yet sometimes, and this is not a criticism, I understand where it's coming from, sometimes barristers and others will see them as a bit of a nuisance, or someone that really, once they've got the evidence, they don't need to take these matters further. How do you see your relationship with those people, and how do you see your relationship with the various organisations that provide support to victims?
Certainly, I can appreciate the perspective that a victim would have, that they would expect to have close working relationships with the PPS and the counsel involved in a case, if there is one, whenever it comes to court. And we do try to balance to say the need to be independent and impartial with we don't lack compassion. And certainly, although I have dealt with a complaint in the past where basically the complainant was saying the barrister met me and what he said is you're just basically a prosecution witness. Yes. And it's not how we view victims, and they have rights and entitlements set out in the victim charter, but that's very much the minimum standard we see. We do want to treat them with compassion and empathy. There are certain legal rules, sometimes difficult to explain them, that we're not there to argue for them. But the justice system has sought to step in other ways. There are legal representatives often involved in cases who do represent the victim's personal interests. You can have sexual offence legal advisors, for example. When their applications are made for their third-party material to be revealed to the defence, they can have representation at that stage. So I think the justice system has improved. There's a lot further to go in trying to make it a victim-centred approach. Unfortunately, because it is an adversarial system, it is quite difficult for a victim to understand that from day one, and we do work with it, and we do train counsel to show that empathy. We recently had a counsel training event where we all would have spoke about the need to treat victims in a way that is in accordance with the victim charter, and we actually had victim support presented that so they could understand how our job is to try and to reduce the trauma that victims feel as they go through the criminal justice system, and not to add to it by being aloof or not available to meet with them.
Finally, Chair, while I appreciate the totality of your independence, from time to time, and I think because the case is now over 15 years over and prosecuted, I think particularly of a case like, for example, the murder of Thomas Devlin, where you were subject to, and I think rightly so in the end because of the final judgment, to having to review the decision-making processes which you took to get to the point of the final prosecution of that particular case. How open are you to those concerns, pressures, and indeed ultimately legal requirements that are placed upon you to take to review the decision-making processes which you make about a prosecution?
We do take those very seriously. They're an integral part of our accountability, and we do seek to be transparent. So I think the Thomas Devlin case was probably a seminal moment for us. In those days, we are going back now to around 2009, 2010, when the case came to trial. Yes. I think things look very different now in terms of how the service operates. And, victims, when there's no prosecution cases, are given very detailed reasons and they're offered a meeting. And then at that stage, they're offered a review, and that review would be internally, and that's what happened in the Devlin case, and led to, in the Devlin case there was a prosecution ongoing, yes, but it led to a further prosecution for other offences. It doesn't happen that often. Whenever we review cases, I think when I last looked, over 3/4 were about 169 cases of last year that we had reviewed, and we changed the decision in 10. I think that was the figure. So whenever we look at it, we do take fresh eyes at it. If there's new material, it goes back to the same prosecutor who may decide, does that impact on the test for prosecution? If there isn't new material, it goes to somebody who hasn't been involved in the case, and it is a genuine look at the reasons for the decision not to prosecute. And where the evidence is considered to meet the test for prosecution, we will take it. Say they're not huge numbers of cases, but we're certainly open to doing it. And of course there is then beyond that, after that's been exhausted, the potential for a victim to bring a judicial review of a no prosecution decision.
And you said that particular case was a seminal moment for yourselves as an organisation. What were the learning outcomes from that? And I think we need to remember that had it not been for the resource and tenacity of particularly Thomas's mother, I'll declare an interest as a former work colleague and family friend. If it hadn't been for the tenacity of the individual and their ability to understand what it was they were trying to achieve, I suppose there's a bit of how long's a piece of string question. How many others are there out there who have been failed by their inability to do what she did?
I think even from then, there have been big changes. I was involved in that case, and I know Jim and Penny fairly well, and I've stayed in touch with them until fairly recently. When the new director came in, one of the first things he wanted to do was meet with them to see exactly what the learning points are. I do think probably now in a case like that, whilst I agree with you totally, they pushed a lot of the victims in types of cases like that now would probably have legal representatives, and we would get a lot more engagement with them even before the decision to prosecute in that case. So when I say it's changed, I think it's raised a lot of awareness, and probably a lot of people think, well, that shows you can, if you get a decision from the PPS that you don't agree with, you can fight and it'll be overturned. I don't think that's always the case. I think it has to be legally the right decision, but certainly we appreciate how individually personal these decisions are to people, and we want to meet with them and explain them, and where the evidence is forthcoming that can change that decision whether or not to prosecute, we will do that where that's the appropriate thing to do.
Thank you.
Certainly, Marianne.
Maybe add, Mr. Dixon, I'm the victim champion for PPS, and the right of the victim to seek a review, I believe, is now fairly well understood, certainly in the victims sector. I chair our Stakeholder Engagement Forum, which has a diverse membership of about 15 plus different sort of cross-sectoral organisations, and speaking about the right of review is very much a feature of the engagement we have. So certainly those who are advising victims ought to be well informed. But in fairness, I don't think most victims would need specialist or expert help to access that right of review. It is explained, we hope, in clear terms in our correspondence, and we are absolutely open. We never resist when a review request comes in. However it's formed, even if it's not very well articulated, we interpret that and we treat it as a review. It is then dealt with at a senior level. So usually the lowest level, if you like, it will be reviewed is by a senior prosecutor. So there is that. I mean, I can certainly give the committee that reassurance that it's part and parcel of our work. It does only comprise, I think, 0.8% of the decisions that we take. So there may be victims who just still don't know how to access the opportunity, but we're doing our utmost to promote it and make it understood.
Thank you very much, Chair. Thank you.
Morris?
Thank you, Chair. Just something I picked up there along the discussions, and thank you very much for the presentation, folks. Very enlightening, but the time that it takes to bring a case to court, particularly for the victim, I think needs massive improvement, and that's something you need to work on and reduce that time, because it does have a massive effect on the victim in particular. The other thing that I've noticed is the time difference between the PSNI and the prosecution service on the validity of a prosecution before the courts, and a ruling on the lack of evidence by the PPS that it doesn't stack up. I know of victims who have been left distraught, and police officers who have put in hours and hours of work to try and bring a case before the courts, only to be dropped at the final stage. How do you plan to reverse that trend where so much work and so much expectation has taken place only for the case to be dropped in the PPS's view through lack of evidence, etc., etc.? I know of one case in particular, I'm not going to mention any names, of a man who was assaulted by 4 people, identified as assailants. Police done an awful lot of background work, and yourselves dropped the case through lack of evidence. Sometimes, to the public perception, it doesn't make any sense. Your thoughts, please.
Yes, certainly, and both valid questions, and others can feel to join in, but I'll give my thoughts on them. So there were 2 parts to it. The first was about delay, and I think I said in the introduction, all parts of the criminal justice system accept that delay is a priority for us to address, but for us it's directly linked to the increase in the more serious cases that have come to us, because we haven't had the budget uplift to deal with it. Unlike other jurisdictions where there has been, if you take in particular historical sexual offence allegations, they're on an increase right across UK and Ireland, which is to be welcomed, that there's greater confidence in victims coming forward. But the rest of the UK and Ireland have responded by investing more in police and prosecutors, and we haven't done that here. So there are backlogs of cases here, even with police being investigated, with us awaiting decision. And unless we start to get the resourcing to be able to bring in greater numbers, I don't really think there's any other way of shortcutting delay. If I can outline just in general, we do work as part of the Criminal Justice Board to speed up justice. And there are a number of work streams there, which I know the committee will be interested in. The one I lead on is early engagement. And it partly leads in, Maurice, with your question, your second question. One of the ways we can try and perhaps, as you said, sort of get involved earlier with police is through engagement in providing advice. We do have a statutory obligation to provide prosecutorial advice to police when asked, but they maybe don't ask us often enough, and they maybe don't ask us at the right time. So there's an early engagement piece I'm working on with the Criminal Justice Board oversight to, firstly, there's three elements to it. See what more can be done to ensure there's effective early engagement between police and prosecutors. Secondly, ensure there's effective communication between prosecution and defence, because quite often what happens is that we take time, police and prosecution, to build a case, thinking that it needs to be of a certain standard to withstand robust defence examination. And in other jurisdictions, notably England and Wales, we notice there's a lot more focus on perhaps the issues in contention between the prosecution and defence being narrowed, if that's possible, through engagement. So one of the things we're going to do is going to see that in action at Leeds Crown Court, and hopefully be able to speak to some practitioners about how that actually does work. And the third aspect then of that work will be around case management, and that's really about just making sure that we have the best, most consistent case management practice we have. That's basically whenever cases come to court, that would be the judges making sure that the prosecution and defence have done everything they're meant to have done by that stage, and that the case isn't still being built on or issues being dealt with while it's at court. Because whenever you're talking about tackling delay, it's end to end. It starts with the police investigation and it ends with the case at court. And there's probably room for improvement at every stage of proceedings there, both from the investigation, prosecution decision, and what happens at court. But unless we start to reduce demand and increase funding and do both, I think what we have here is quite an expensive justice system for dealing with less serious offences. As I outlined in the introduction, some of those wouldn't get to a prosecutor in the likes of the CPS or indeed the Republic of Ireland. And we do need to have discussion amongst politicians and perhaps consultation about, are there more proportionate ways to deal with lower level crime? Could we take some of the offences that are in the Crown Court and perhaps are at the less serious end of that and put them into the Magistrate Court? And then that would maybe free up resources for us to try and get those cases that have to go to the Crown Court and be pushed through a better level of service to victims, but also do it more quickly. But I do think we have to be realistic that there needs to be a resource investment, and there also needs to be some modernisation and transformation of the current system.
Yeah, thanks very much for that. Very detailed and very interesting response, and I wish you well with that, because I think you've hit on something there. So thank you.
Thank you, Maurice. Doug?
Just a very quick one. Public confidence has been rocked recently because of unduly lenient sentences, and I think you have the ability to call in unduly lenient sentences. Are you seeing an increase in that? Because I certainly know I've written to the office on a number of occasions about that very problem. In particular, if I can, they seem to be unduly lenient sentences in regards to sexual offences.
I think, Doug, there is certainly a perception out there that there is an increase. I'm not seeing an increase. We only take about 6 cases a year, and but I would probably look at maybe 3 times that number of cases in a year as potentially unduly lenient sentences, and we do look at them very carefully. There is a high threshold for bringing an unduly lenient sentence. There's a recent case of Sharia Ali last year that really says, look, there has to be something that the judge has fallen well short on, and probably some procedural error involved. And it's not just that it's a lenient sentence, but it's one that no reasonable judge could have imposed given all the facts and circumstances. Sentencing is a difficult exercise to undertake, and I can understand why people are often disappointed about the sentence. If I may, I think one area that I maybe take a slightly different view on than some other practitioners is around the discount given for guilty pleas, and I think they have a much more they've got a statutory scheme in England and Wales that doesn't maybe afford as much flexibility as it does here. So in England and Wales, I'm not exactly comparing like for like. If you plead guilty at the earliest opportunity, which over there would be a sending hearing to the Crown Court, so it's a slightly different system there, you're entitled to a full 1/3 credit. Then after you've been arraigned in the Crown Court, it's a sliding scale, and it's usually between 25 and 20% then going down, and you will only really get, it's expected if you plead guilty on the day of the court, you get about 10% credit. So it's fairly clear what you can expect. Bit more flexibility here. I mean, we have brought unduly lenient sentences because we felt the discount has been too generous. One of them was a terrorist case, Gavin Goyle. Recently, the sentence was increased from 6 to 8 years. And certainly there was a full credit, 33% given at a very late stage in proceedings that we argued was too generous in the circumstances. So that is one area where I am seeing an increase in the trend of being requested to look at it. As I say, I think the judges do an excellent job here in sentencing. There is going to be a sentencing bill, as I understand it, introduced later in the Assembly mandate. And some of the issues around early guilty pleas, I know we're going to discuss further at the Criminal Justice Board, and there may be further debate about whether it's better to have a system that gives that greater clarity and consistency, or whether we want a system that affords the greater flexibility that we currently have.
Yeah. And certainly that sentence credit is the issue that a lot of people are looking at as well, particularly if somebody goes right up to the last moment, puts people through the whole rigours of a case, and then admits guilt just as it's sitting. I think that's a problem. Can I just ask you another quick one? Stephen, it's the dreaded legacy. I'm going to ask you on now, because I know for a fact that you're under serious pressure. You know, you nearly need to have two branches. You know, a PPS legacy branch and a PPS. I get that. We've had these discussions, I think, before, but your predecessor certainly used Section 35(5) a lot to bring cases forward. Is that still the case? Are you still having to bring forward many cases under Section 35(5), or? Well,
actually, after the Legacy Act was passed last year, there is no Section 35(5) provision. I'm not one of the people who can refer a case to the ICRIR. Now, whether that was a deliberate construct in the legislation or not, I don't know. But, and I know there's a potential, say, I'm not straying it too much, for the Legacy Act to be revisited. I think, just focusing on the legacy in particular, I do recognise the right of victims to ask for cases to be looked at, even though a murder occurred 50 years ago, as if it happened today. I do recognise that. I do think there has been a lack of appreciation of what that's involved, or maybe a lack of consensus of the finer detail. So whenever I hear, for example, there may be a potential to go back to the Stormont House arrangements, I think there needs to be a lot more discussion about what does that actually mean, because as you've touched upon, we would need a separate legacy prosecution unit, because the investigations into legacy, there's a lot of resource put into them, and it's not matched on our side, and it does frustrate us, as I'm sure it frustrates families waiting for decisions, that we can't prioritise them because we don't have the resources. If anything, we have had to prioritise the 30% increase we've had in the more serious cases, 50% serious sexual offences. So we have put additional resources into our serious crime unit, but we haven't been in a position to do that with legacy. And if the legacy arrangements are to change, I will certainly be advocating again for a separate legacy prosecution function within the PPS, rather than going into a unit that deals with all the current day terrorist cases and the likes of Muckamore Abbey. I think when I was here on the last occasion, I outlined my concern that there would lead to frustration and delay if we didn't have a separate unit, and that never came to pass. We never got the funding for it.
Thank you.
Do you agree?
Yeah, no, thanks very much just for your update. I suppose a couple of things around the broader public understanding of the office in terms of the decision to prosecute around the evidential test and the public interest. And I know with some of the recent, obviously, decisions that were taken, you've released more detail in terms of public statements to explain that. So It's just to see if that's going to be an ongoing practice. Do you feel that there's a need for that? Is there more that the office could be doing, notwithstanding some of the resource pressures that you talk about that you have? But just to allow the public to understand these things, because obviously the next piece of legislation in terms of looking at sentencing will come next year, we're hoping, and obviously that will be of public interest as well, and we want to make sure though that it's not the historical bit, you know, that it is a proper informed conversation. So it's just to get your view in terms of where you see those tests and how that sits with the broader public, and if there's more work either from previous cases, you know, in terms of lessons learned that the office could be doing. And as you say, how that sits with the test for the prosecution, the kind of code of practice for prosecutors that you touched on. The other issue then was around, I suppose it's the resourcing issue and the case progression. So just the investigation, the file from the PSNI. I know you touched on that you're doing a bit of work, but is there more that needs to be done to front load all of that to ensure that there's as much of the evidence there? And what more can be done with the PSNI in terms of looking at that? I know back in April you'd made public comment just around the crime unit within the PPS in terms of 200 cases that we're still waiting on assessment. Is that still the kind of level in terms of those cases where there hasn't been enough evidence? And again, is that around particularly the sexual offences of an historic nature? Is that where some of that is coming from? Because obviously we're concerned that we've heard previously just with the length of time it's taken those sexual offences, approximately 9 months. And just what work can be done then to try and speed that up? Is it a resourcing issue? Is it the evidence in terms of the PSNI and other agencies? What more? Because obviously the access to justice, the delay in the system is a big cause of concern for the committee, and it's something that we'll want to look at. We're going to be getting a briefing after this in terms of the budget from the department as well, and obviously these will be things that we'll be probing in a bit more detail. So it's just to get a sense from yourselves in terms of those issues. And then I suppose I was interested in your last point there around the modernisation piece and offences, and just I was looking at just stats now. These are from NISR back in 2020-21. So just the majority of your offences, obviously around 30% in terms of violence against the person, another 30% in terms of motoring offences. Is that still similar in terms of the breakdown? And then also there was, I think, just under 600 files, with a good percentage of that, over 50% coming from the DVA. So again, is it around those areas that you feel there could be modernisation in terms of approaching them differently that would then allow you to focus on the more serious offences? So just to get your sense of that modernisation piece, and are there active discussions going on with the department in terms of speeding that up or maybe looking at that differently?
Okay, well look, I tried to be clever there and didn't take a note, so I'll try and I'll work backwards because I'll remember what you said most recently. On the modernisation, and I suppose it's really about reducing demand. There's a lot of aspects to it, and I think we all want to speed up cases, and we want to spend the money where we're going to maximise the benefit of prosecutorial input. I am not persuaded that there needs to be prosecutorial input in every case. Might be a strange thing for a lawyer to say, but lawyers are expensive and they don't always speed up things. So we are looking very proactively at the Criminal Justice Board about what can we do at that lower end piece, and there are a number of options. But one of the things I'm not sure the committee heard of or not to date is we have a pilot running with police around this idea that there be a no further decision file. So as I outlined in the CPS, police do not send a CPS every case. If they think it's evidentially weak, they don't send it to the CPS, which is why we have more no prosecution decisions, and why, going back to the first part of your question, Deirdre, why we're probably having to explain more no prosecutions. We have more of them in this jurisdiction than we'd have elsewhere. But we've reached a pilot arrangement with police where in certain categories of cases where they're lower level offences, they wouldn't send us the file. So what they do instead is they have cases referred to at Spectre level within the police, and they take a decision that, look, that's not going anywhere, we don't think that's going to meet the PPS test for prosecution, so you need to send the file. They would still provide a review mechanism within that, because sort of, as we spoke and as Marianne spoke, there is a right to review. So part of the work we did with police was ensuring that they had a right to review, as is the case in England and Wales. If police take a decision not to send a file to CPS, there's a right to review there. So that is one way in which it might reduce demand in the number of cases coming into us. But there also needs to be, you mentioned, and you're spot on, about 30% of the prosecutions we have in the Magistrates Court are for road traffic cases. And I do think there is scope there for looking at, look, can we do those in a way that doesn't always involve police sending a file to the PPS taking a decision documentation going from our office, getting the courts involved. All seems to me to be a lot of layers for what can sometimes be fairly low level crime. And as DPP, I'm obviously going to say all crime is important. I'm not saying that there are some crimes that should be ignored. But the other area I think there needs to be maybe a lot more collaborative working is around looking at the root causes of offending, because if you see some of you talked about the offence times that are on the up, so violence against the person, acquisitorial crimes like theft, retail crime, I think we are seeing a link that there's an issue there around drug use and around mental health. So the easiest thing to do if you're looking at that end-to-end approach is try to put your resources into preventing crime in the first place and addressing, because quite often we see a lot of people coming before us who are recidivist offenders, and quite often it's because of their drug use or their addiction to prescription medication even on some occasions. So I think there has to be more joined up working about how we take cases out at the very front end, and that involves maybe not just justice but health and education and other departments. And then whenever the cases do have to come to us, we're very much, prosecution is a last resort. Obviously for more serious offences it's going to be fairly natural. If you've done something you're going to end up in court, but there's a lot of other areas where there's alternatives to prosecution, and you don't always have to prosecute somebody in order for that case to be dealt with appropriately. And I think that's where there needs to be, in this Assembly mandate, maybe a lot more discussion about ways we can do it. But it is something we're very actively looking at the Criminal Justice Board.
Okay, thank you.
Can I come in?
Yes.
Deirdre, just in relation to build on what Stephen was saying there, he talked about the no-file decision pilot, so cases don't need to come to us in the first instance. And that's sort of one very small part of a wider modernisation strategy that we've developed for PPS. Perhaps not the most creatively named PPS 2030, but there it is. There's 4 themes within that strategy. The first one of which that no-file decision is part of is about proportionate processes, and it's about dealing with cases in the most appropriate way. Not everything needs to go through a really detailed process. You mentioned there the figures about the number of road traffic cases that are still in the magistrates' courts, and a lot of them are, and a lot of them go through the prosecution decision process, go to court, get in front of a judge, only to have the exact same penalty that would have been imposed had they got a fixed penalty. And we know that there are structural reasons for that. We know that currently if you get a fixed penalty, you get 28 days to pay it, and there's no flexibility with that. It's not like a fine where you can get an instalment order, or there's not the same range of payment options. So one of the work streams that brings together the DOJ, the police and us is looking to see, can some of those barriers be taken away so that those really low level cases don't need to be there if the only reason they're there is because they needed more time to pay. We're also looking at ways to be more creative about how existing out-of-court disposals can be used. So things like fixed penalties, penalty notices for disorder, there may be certain criteria there which prevent them being used in an individual case. And there's just a general view to see, well, can they be, without having any adverse effect, can they be loosened to allow them to be used more flexibly? And Stephen's talked about the remit of the magistrates' courts. Now that's a longer term piece of work which would require legislation, but we do have backlogs in the Crown Court. We have sort of delay in dealing with the most serious cases. It's almost like a linear process. If we can take out some of the road traffic cases, if we can deal with them in different ways and clear up capacity in the magistrates' court, there may be scope to increase the sentencing jurisdiction of the magistrates' courts and allow some of the Crown Court cases to come down into the magistrates' court. At the minute,
again, we're working with DOJ to review all the cases that were in the Crown Court in 2002 that had either a non-custodial sentence imposed or a relatively low custodial sentence imposed, and we're looking at them to say, well, had the jurisdiction of the magistrates' courts been higher, had it been 18 months, 2 years, would you have been happy for the decision to be made to try it summarily? Yeah. So that's that. You talked about the working relationship with the police. So the second big work stream within 2030 is about effective processes. And that is, I'm not going to touch, Stephen's talked about early engagement, so a lot of that's about early engagement, how we engage with the police and give advice at that early stage. But a big bit of it's about file quality. We need more of the files to arrive with us so that they are almost decision ready. We need to try and minimise the amount of time that we spend going backwards and forwards with the police and building that file. So one of the pilots that we're looking at is a gateway model where we would have dedicated teams on both sides, in police and in PPS, trying to be very clear about what the file build standards are and trying to make sure that more cases meet that standard before they arrive with us. And then the last big chunk in there, again, which the director alluded to, was the growth in technology. We now have shed loads of files that are coming in with body-worn video attached to it or CCTV. That makes them inherently more time-consuming for prosecutors, but also we're getting lots of body-worn video in which doesn't meet the standards that we've set out. The clips are too long, there's lots of stuff in them that isn't relevant, that isn't evidentially relevant to the case. So trying to use that gateway to get more compliance with the standards so that, again, we're not wasting a lot of time watching video that we don't need to be watching. The last two, just very quickly, digital processes. So again, we want to build on what we've already done. We are still, the justice system as a whole is still quite a paper-heavy, manual process-based system. Quite recently, we've started sharing multimedia evidence using Box, which is a cloud-based system, and using that to serve on the defence. That's worked really well. It's reduced a lot of manual handling, and it has the potential to be used much more broadly. Yeah. You know, if we get to the point where we're able to start digitising paper evidence, yes, we could serve that way as well. And that should hopefully be a precursor to something which would, again, need to be led from the centre, need to be led by the department, but maybe moving to fully electronic bundles using the case line solution that they use in the Crown Court in England. So you can see a lot of themes which we're starting off with fairly baby steps, but they have the potential to really radically reform the system.
And that's all within that strategy then?
That's all within that strategy. Okay. I'm happy to share that with you.
Yeah.
Can I just finish with one more piece? One thing that we are working on and which we hope will be in by the autumn, and it sounds very narrow when you look at it, but for us it'll have a really big impact, and it's digital signatures. We're moving to the point, so instead of having to have summonses with wet signatures, we're developing the IT system so that it will apply a digital signature. It will allow all the papers to be compiled and reviewed and approved digitally. The amount of time that will save for our admin staff, for our prosecutors, is phenomenal. Now, we are still at the stage where it will go out the door in a paper form, but hopefully it will lead on to better things.
Very quickly, I'll maybe pick up on your first question. I think we've done number 3 and number 2. And the first question was about our use of public statements, which, I sort of take your question almost as welcoming of the fact that we've been doing it. And I think it's something that we have done over a period of time. It's obviously not really proportionate to do it in any case. No, we have a fair sense of the cases in which the public have an interest and in which we see the benefit of doing that. And we have received positive feedback from a range of sources, I think, in relation to do that, or in relation to doing that. And I think it is absolutely fundamental to, I think, public confidence in us and the public understanding what we do. I think the director's opening comments referred to us often being misunderstood. Understanding the code, the test for prosecution, is a great starting point for understanding what we do. And so, do we anticipate continuing to do it? Yeah, absolutely. Where the right cases arise, we will continue to do it. Obviously, in more serious cases, we give detailed reasons letters to victims. So even though the public might not be seeing detailed reasons and an explanation of the test for prosecution on a case-by-case basis, victims will be, particularly in more serious cases. So that's the other important thing. It's not all we do when we draft these statements. Try to make them as readily understood as possible. It's not always that easy. Some cases are easily understood. Some cases are based upon legal rules around the admissibility of evidence, which are quite difficult for a non-lawyer to read and to digest and so on. But we'll keep trying. The public statements are obviously just one means of communication and explaining decisions. The face-to-face meetings that we would have with those directly involved are usually a better, a more personal, more detailed way of explaining decisions. So, we're fully committed to our decisions being understood, because I think public confidence in us will be higher when they are understood. I think it's when they are misunderstood that is very unhelpful for us as an organisation.
Thank you.
Chair, may I just pick up I think the final aspect you raised, Ms. Hargey, which was about sexual offences and delay. Shall I?
Yes, no, I'm glad.
May I
you
take
were
that
taking
point?
notes there, yeah.
So I would oversee the serious crime unit. They don't deal with all sexual offences. We get about 1,600 a year on average, but they deal with about 1,200 per annum, so I have oversight of that, and then the regions that deal with the remainder of the cases. And just looking, I'll try to be brief, but over the last year we've actually seen a 23% increase in the sexual offences reported to us. The serious crime unit, which deals with about 1,200 of those per annum, is actually a very small unit, and I suppose I'm keen to convey that. The capacity assigned to that unit is only 10.3 senior prosecutors. It's a very expert team, and when I say they're passionate about the work they do, I truly mean that, and we couldn't have survived without the commitment and the expertise of that group. We now have a cadre of 13 prosecutors, which is still not enough, even close to meet the demand, and they're supported by 6 public prosecutors. Last year we had received a total above our sort of baseline of about nearly, it was actually 1,858 cases. And during the pandemic in 22, we'd really reached a crisis point, and I think that's what you were referring to, maybe from a previous committee. So we had got to the point where we had almost 600 cases being handled by that unit pending decision. And these are all very significant cases, clearly just reaching a point where it was going to be out of control. So we borrowed a resource from other parts of the organisation, and over the course of 12 to 15 months, when I checked today, we are from about almost 600 down to 259 cases pending decision, which is really a remarkable improvement. But to get to that point, we had boosted the resource by, I think it was up to about 18 senior prosecutors at one stage. But I suppose what the committee might be pleased to hear is that in terms of the delay point and how that has affected not just the volumes of cases but the timeliness, our median timeliness has reduced. This is sort of end-to-end time while we have the file, has reduced from 232 to 135 days from point of receipt to decision. And that includes where we might have to go back to police to get some clarification or further information. If it's a no prosecution decision, our timeliness has reduced median time from 71 to 27 days. So you're seeing, and it's no surprise, the direct correlation when you've got close to the right resource, what you can do with it. We're assisted, and actually when we look at the stats for cases involving children, there are specific arrangements. And of the cases we've dealt with in the last 6 months, all were decided within 2 months. And in one instance, a particular case was decided on the day of receipt. So again, I love to reach a point where the work is demand-led. We have enough prosecutors to basically receive the file within a day or two of us actually receiving it. We're very much assisted within that unit in that we do have a gateway team. It's the only business area that has a gateway team. So we have a quality assurance check on police side. We have an agreed file build with police, and then there's a second check when it comes to us. So it's not entirely 100%, but close, right first time in the majority of cases. And just yesterday I was meeting with senior police from Public Protection Branch. We want to devise a joint strategy for the investigation, prosecution and management of sexual offences, to set really ambitious goals. So we've more or less halved the time in a year, but we want to go well beyond that. But we don't have complete control. There are police resourcing issues. We have no kind of handle on what the court will do with the cases. And that's why obviously the ambition would be system-wide. But it's quite exciting, and it really does seek to really push down the time for those cases.
Oh, thanks very much.
David, Justin?
Thanks, Chair. Hey, folks, how are you? In terms of, Stephen, you mentioned more proportionate ways to deal with lower level crime and your resource investment and your modernisation. Give me more information in terms of what you mean by that, in terms of low level, what the possibilities are there, please.
Yep. Say one of the things Peter talked about, it's all about reducing demand, Justin. So we do have a model because of the sort of contested political criminal justice history here, where we receive every file from police. So the first thing we're trying to do is say, well, look, what about if we didn't? Because we've got very high correlation rates between where police were sending us a file saying we recommend no prosecution, or their thought was no prosecution, and us actually deciding not to prosecute. It was between 96 and 97% quite regularly. And we do think there is probably, and I know it's always something that be up for debate, a different, greater confidence in policing than there was at the time of the Good Friday Agreement and whenever the PPS was set up. So we think times have changed in that regard. There's certainly a lot of accountability around the conduct of police, and I think whenever it comes to lower level offences, I don't think there's maybe the concerns that any potential, if people had concern about it, about police bias or anything like that, would really impinge on low level offences. As I say, in other jurisdictions they don't have those concerns and they are routinely dealt with by police. So we're testing the water about whether that will work, whether that will reduce demand, but also, as Peter was saying, we need to look at, that's just cases coming to us. Whenever they come to us, there are other options for how we would actually deal with that case. So if you're having to have every road traffic case, and about 30% of our prosecutions in Magistrate Court are road traffic offences, there's a great scope for trying to do those differently, maybe streamline how they're done, group them together, possibility of prosecutorial fines, doesn't involve the judge. In England and Wales they have what's called the single justice procedure. There are a lot of options there that don't necessarily involve a high level of prosecutorial input, and I'm actually suggesting we'd be better off either you send them to us and they don't go to court, or you don't send them to us at all, are the two areas I think that we should be looking at whenever I'm talking about more proportionate processes in lower level offences.
Okay, and where is the workload at, the resource investment at, and where's morale at within the PPS? Obviously there's a great rapport between all of you and a great team ethic at the peers. What's the esprit de corps like in the PPS, and what's the outcome of the legacy legislation, which has been described by Amnesty International as a cliff edge for truth, justice and accountability? What's the outworkings of that in terms of the demand on you, in terms of your workload with that cliff edge having passed? Legacy Investigation Bureau, obviously we're up to Haido trying to get those prosecutory statuses progressed in time for the advance of that cliff edge. How did the LAB dovetail with PPS, or did that happen, and where are resources at now?
Okay, well, say first one about resource and morale. I'd say we've got a funding settlement, budget settlement this year that allows us at least to try and bridge that gap between, we were always starting between £1 and £2 million short than what we needed, even to pay the cost of staff and things like that. So we had a lot of agency staff without whom we couldn't run the business. But obviously if you're a line manager in the PPS and you're getting an agency staff member starting on Monday who gets a permanent job a couple of weeks later and you've just trained them, and that's the constant cycle that we've had for years, that can impact on morale. Obviously the rising workloads that were coming in that we've talked about without resource impacted on morale, and have to be fair. Probably staff would say the issues around file quality that Peter's touched upon and the working together with police, there's been a lot of goodwill, a lot of good working relationship with police, but maybe the end product on that, I would say those are the three major factors impacting on morale. I hope it is slightly improving. We had a staff engagement event last week, and the questions the staff asked us do show we've got a very committed and dedicated workforce, do show they are under pressure. We've had increased levels of sickness, but hopefully the budget settlement, if we were able to spend it in a way that starts to fill the gaps in our staffing levels this year, and hopefully next year we'll be arguing for more funding to start to grow the organisation in terms of getting more people in. That'll start to turn staff morale. On the legacy front then, say we haven't been involved in any close way with any policy implementation. We had been, like everybody else, thinking the Stormont House Agreement was going to happen until the turn of events that led to the Legacy Act. We did try and get, obviously, any case that was with us for a prosecution decision before the 1st of May deadline, we did get through. It wasn't that we rushed them all at the end. I know it probably seemed like that because there was a lot of decisions went out between Christmas and May. A lot of those cases had already been with us quite a long time and were under consideration, and we obviously did our best to do that. There was an amendment that we did work with NIO on that allowed the cliff edge, as you've put it, Justin, there, just to be softened slightly. So anybody who wanted a review of that decision taken before the 1st of May could do so. And we have a number of reviews ongoing. Michael, I don't know if you could...
I do. I have at least 10. Sorry, we have at least 10 reviews. So and I suppose in terms of the continuing demand, it's not like for the 1st of May, legacy is no longer on the plate of the PPS. We have a number of cases at court, some of which still have a considerable period of time to run and take up a lot of time and energy of some of our senior prosecutors. The LIB that you mentioned, they have a caseload that doesn't stop at 1998, that goes on to 2004. And I believe there's maybe in and around 150 cases. So in terms of the flow of cases from LIB to PPS, I'm not expecting that to stop necessarily. I'm just expecting the profile of those cases to change. So because they'll no longer be dealing with the ones up until 1998, their attention and focus is already on some of the sort of later ones within their work queue. And I'm not also aware of any really change in the resourcing of that unit. So we will still continue to receive a workload from LIB. We have, as I say, at least 10 reviews that we'll have to resource, and some of those are in very complex cases, so all of that's ongoing. And then, I suppose, in terms of we obviously have the ongoing litigation around the ICRIR, and we will potentially be receiving files if that organisation does conduct criminal investigations and submit files to us. That's probably the biggest unknown of all the different demands at the minute, because I don't think anybody really is able to sort of project with any accuracy how much engagement there will be with that body and how many of those cases that they look at will result in files coming to the PPS.
Okay, in relation to legacy, you mentioned veterans, you mentioned state actors. The majority of my community, Republicans and Nationalists, were killed by terrorists, the IRA, namely. Why was there no emphasis on terrorists? So why were just state actors and veterans mentioned?
Oh, no, sorry, Justin, I was only just saying that shows you how some of the criticism of us is in fact contradictory, because you've got some people saying we're on sort of a witch hunt or a pursuit of veterans, and others saying that we are reluctant to prosecute them. I was only using that as an example of how sometimes criticism of us comes through whatever lens you're looking at.
Can you as an organisation give a view on the legacy bill, or is that within your...
They've gone to great lengths to keep me out of the political arena through the setting up of the PPS, but I don't think I'm treading in inappropriate territory to say I recognise that what was, as I said the last time, nothing had really happened from the Stormont House Agreement. It wasn't happening at a pace that was delivering for victims, and it was coming at a huge emotional cost. We could see that. So, on one hand, the ICRIR, I think, has the ability to provide answers. There's a difference between what is needed to perhaps put a file to the PPS for a possible criminal justice outcome and getting answers and information. And I don't think the process of getting answers and information should stall while we're debating about what happens in the criminal justice arena. I do see that, because these cases are now 40 or 50 years old, people have been waiting a long time even to get answers, and the prospects of criminal prosecutions and convictions are getting vanishingly small in these cases, and I do think time is of the essence. So my only concern about this cycle of having a process, Stormont House Agreement, and then that's abandoned and we go to the Legacy Act, and then you've got the possibility of going back to the Stormont House Agreement. They're not time bound, they're not funded. Nobody really addresses our mind about what it takes to prosecute legacy cases, and that's why we have never been given separate funding for a legacy unit like we had asked for from 2018 and again in 2021.
Okay. Very quickly then, you mentioned digitisation potentially of files. To what extent would AI be an assistance in terms of moving cases forward, or has it been explored? And why the 23% increase in sexual offences being reported in the last year? Why has that happened?
In relation to AI, yes, I mean that's an issue which has the potential to help us. I mean, one of the areas where we know AI is being used is to deal with redactions and in the context of disclosure. So we'll certainly look to see whether that could be a benefit, because that is an area which takes up some considerable staff resource, both within our organisation and within PSNI. So yes, it has potential. I wouldn't say we have embraced it to any great extent yet, but it's certainly part of the strategy.
And to take the query about the 23%, it was an increase between 21-22 and then 22-23. And we've spoken to police at various intervals. Sometimes you'll see a bit of an annual fluctuation like that, and sometimes you'll see a very peculiar spike in an individual month. And there is no individual trend or explanation for why that has happened. I mean, we would hope that part of it is due to the increase in public confidence, that we are much more, I suppose, publicly visible. You know, I do my piece, as do all the senior team and our prosecutors, just to try to build confidence amongst victims, but also through the stakeholder sector, and see if we can influence behaviours that way. So I hope is at least part of the explanation. Also, in terms of the timings, it was coinciding with all of the pandemic restrictions being released, and I suppose perhaps a return to more normal social patterns. And that's purely speculation on my part, but I think it does coincide, interestingly, in time with people returning to normal socialising and so on. So I can't give you a specific answer, but that's my best.
Trust in the system as well.
Yes, yeah, that's what I say. Public confidence, perhaps trust. I hope that is the case.
Well, thank you.
Justin, so just me. Can I say? Before I get to my questions, I want to thank you. You've been extremely generous with your time. It's been really helpful to have your briefing, actually. I think it's important. We understand completely that you're not accountable to us. However, it is important that we understand the nature of your work and we're able to ask you questions, because what we do see is that your decisions, one way or another, impact on public confidence in the system, its partners, and you as well. So I want to acknowledge that initially. I also acknowledge too that you don't want to speak about specific cases, and I respect that. There are a couple of issues that I would like to raise, touching on things that you've raised, and I'll speak in generalities.
No, absolutely, no problem.
But I think that I should, because they are issues that touch on public confidence. But first of all, I do want to thank you, because I think it's been really helpful, and we'll speak about your generous offer to come every 6 months, and to help us with legislation. So 6 months might be a wee bit often, but for all concerned. But I'm sure we can work our way through that, and thank you very much. So just with regard to a few things that I have. In terms of the decision to prosecute or not, and you have mentioned delays in the system and so on, but there have been a couple, and you've also mentioned public confidence, political viewpoints, and all of those things. And I accept your independence entirely, but we're all part of wider society, and we're hearing, and we have our own thoughts. And what we've witnessed recently was a high-profile report where the police had felt they had met significant threshold levels. But some of those files that were given to the PPS took 2, 3, 4 years to come to a decision. And that has a significant impact on public confidence. And then the outcome is, no, we're not going to proceed, when the police think the thresholds have been met. So that damages confidence somewhere for somebody. Likewise, we have seen prosecutions, high-profile cases where the defendant was clearly dying and died in the midst of the trial. And you're kind of left to think, I'm not sure where the public interest was in that and in the money spent on legal aid in those cases. So how do you find the balance? You know, for people looking on who start to think, oh, you know, people will see, as you have said, people will see to an extent political expedience. I think the public statements help massively for people to understand the distinctions between the role of the PPS and the PSNI and so on. But how do you find the balance?
No, Chair, I'm happy to take those questions. And the good, you mentioned political expedience, and I know, and I recognise why sometimes people think that is a factor in decision making. It's never a factor in PPS decision making. It's all about legal process, and we're accountable through the law. So everything is rooted on that. And it's an offence to try and improperly influence the director. I have to remind these folk about that sometimes. But in genuine terms, with the legacy cases, you're talking about Operation Canova. I did, when I was here in 2021, say that I was concerned about the resources that we had available to deal with that case. And it's not that they came into the PPS and sat for years with nobody working on them. And there was back and forth between prosecutors and investigators. Not all files were complete when they came in. And we were certainly working as hard as we could. These were complex cases, but it's the nature of the evidence in them. A lot of them are talking about documents that are incomplete from years ago. You're not able to tell who the author of it is, so there's issues around the provenance, there's issues about multiple hearsay, and they all feed into admissibility. I think there was a lot of optimism and enthusiasm around that investigation, which is very welcome because it gave victims, and hopefully will continue to give them, a lot of answers. But it's our role to obviously take an objective viewpoint of the evidence, and we did that in these cases by engaging very experienced counsel based in England and Wales. So it's not as if even there was a Northern Ireland slant brought to this, that this case might have been prosecuting in Wales. It wasn't here because PPS and local council took a view. We used counsel from former senior Treasury counsel in England and Wales, very experienced counsel that prosecuted a lot for the CPS. And so the issues were around the evidential threshold not being met. Any prosecutor's view is useful, but it's only their field for the case. Unless you've sat down and you've read all the evidence and you've taken everything in context, you cannot form a view about whether the test for prosecution is met. And I think in those cases there was a lot of speculation about it, a lot of assumptions, because the investigation was quite long going, very high profile, talked about finding things hadn't been found before. I think the expectation levels were raised. And certainly we did our best to explain those decisions. The decisions were issued over 4 different tranches, and I think with something like 92 pages. I accept that the legal explanations can sometimes be hard to penetrate for an individual. Michael certainly did a bit of media work around that, and I'm here today as well to say they were purely evidential based. There were no improper considerations at all.
Even see
in those
the
cases.
The 2, 3, 4 years thing has a massive impact on public confidence around these issues.
Yeah. And just on that, I understand that, and I've said publicly before that we'd had more resource to do this case more quickly. I would have welcomed that unequivocally. The files came in over a number of years. So, yeah, absolutely, there were files in 2019, there were files in 2020, there were files in 2021, April and November, there were files in 2022 in February, and there were actually a couple of very late ones in December 2023. And the approach to the decision making was, it was recognised, I think, by all the team involved that this is not the type of case where one should be looking at files in isolation. You had to look at the totality of it, and that was to bring to bear it at its absolute height. And so that was the approach that was taken, and the scale and complexity of it, was really quite unprecedented. So it was always going to take time, but and the investigation had been working and gathering evidence for about 3 years, with a significant team of 60 or 70 staff before it came into us. So, I only sort of state those facts to provide some context. I understand from the public looking at it, it still feels like a long time to take decisions. But the prosecutors that we had, worked their absolute hardest on it, whilst balancing competing considerations. We didn't have a separate legacy unit that could deal with this in a sort of ring-fenced way. We very much had tried to prepare the ground for these files coming in. We had two of our experienced senior prosecutors ready to deal with them, but they still had some cases from legacy cases in a different sense, cases that they dealt with previously that would then come to court when they were working on these cases, and then they'd have to deal with the cases that were at court before they could get back to the Canova cases. So it wasn't ideal. It wasn't the model of how you would want to do this in an ideal world in order to deal with the cases as quickly as possible. But it was the best that we could do in quite challenging circumstances. And we have tried to explain all of that. Sometimes the detail in the explanations it doesn't communicate as well, maybe, as just the headlines. And that is a challenge, that we do face.
That's fair enough, and I'm grateful to you for answering it. Just to follow through then, in terms of review, for example, you've cited there that a victim may appeal. I imagine for some, they would be financially precluded from doing that. But in terms of reviewing your own processes inside and whether or not, do you take time to review whether or not a decision was the right one? So, for example, in circumstances where you're midway through a trial and somebody dies, it's fairly evident that they're going to die. Do you review after these cases and consider, have we made the right decision? Are our processes right? Are the factors that we take into account, because you've mentioned flexibility, Stephen.
Yeah.
To what extent do you look through and consider introspectively, okay, where are we? Are we still on track here?
The system does take into account, obviously, that generally speaking, if you're prosecuting somebody who is ill, is in health, or has potential fatal condition, you can only ever seek to put them on trial, probably for the most serious offences. The other offences, there is a degree of proportionality and question of fairness. And in every case, you always get representations from the defence, be it medical reports, that would come to us that we would consider. And in fact, we've had cases where I have invited, before I've taken a decision to prosecute, I've invited the defence, because we've had a medical report, we reviewed the case, and I invited them to submit a further medical report to see if the condition had worsened. So in those cases, the system does build in that obviously you don't put people on trial, it's a serious thing, unless you know it is proportionate to the offence that has taken place, and there's evidence to do so. And there has been occasions where we have stopped proceedings because of the medical evidence saying that this person will not be able to give evidence, or to put them on trial at all will be so detrimental to your health it may bring on a fatality. Obviously, from time to time, it happens in every jurisdiction. There are cases that are in progress where someone dies, and of course that's very sad and very unfortunate. There are individuals involved and families. But it's not that it's due to any sort of oppressive conduct by the prosecution or overzealous approach. It is right whenever something serious has been, a crime has been committed, that somebody is made accountable for that. And the system does, as best as it can, try to cope with any medical conditions that individual has that could be accommodated by how the trial is run. Or on some occasions, as you say, their condition is so bad that the trial actually stops, and we do review. We do keep all decisions to prosecute under review, and if we got medical evidence alerting us to something that was very significant, that would be taken into consideration, of course, yes. Yeah.
I mean, it is an explicit duty on a prosecutor to keep their decision under continuing review.
That's helpful, thank you. And I think it's actually helpful to have that in the public domain, to be honest. Maybe to stop some discussions around some of these issues. With regard to, you've mentioned a few times the work on the Criminal Justice Board, and you mentioned one particular project in which you're leading, and we're really interested in this work and in the modernisation work. Maybe you could give us some outline as to any other elements on which you're leading and what the progress kind of is thus far and potential timeframes.
We've touched on a lot of them there, so I'm leading on the early engagement one. Which is probably, we haven't mentioned committal reform yet, so committal reform is probably something that we'd have talked about the last time Michael and I appeared before the committee. So the Work streams on the criminal support or committal reform work stream. There's one ongoing. There's digital strategy. There's out of court disposals, which I think Peter probably touched upon. Maybe look, police in particular leading on that, looking at ways in which they may use the powers they have or extend them slightly to deal with lower level offences. It don't mean send them to the prosecutor. Also looking at what we might do. That doesn't mean we send the file to court. There's the early engagement, and then there's the remit of the Magistrates Court, which again Peter has looked at. Now that's the one with the longest time frame, and really I suppose my vision, and I hope it's shared with criminal justice partners, is that the public expect us to focus our resources on the most serious cases. Say every crime is serious, and especially when there's a victim, they will feel it very personal. But when you've got finite resources, I think looking at cases where the most vulnerable are, the current threat of risk and harm, I think is where we should prioritise resources, and police and I agree on that. So if we had less cases in the Crown Court, that we could do more quickly, that we could provide better standard to victims and witnesses, I think broadly speaking, the committee, politicians, society would say that's probably the best way to spend the money. That would mean trying to take cases out of the Crown Court and into the Magistrates Court. At the minute, the maximum in most cases you can sentence in the Magistrates Court is 6 months and £5,000 fine. Some offences you can go up to 2 years. If you increased a lot more offences to 2 years, you can see how you can take cases out of the Crown Court into the Magistrates Court. But you also then have to find a way to make capacity in the Magistrates Court for those additional cases you brought in, and you do that by taking the lower level stuff out of the system altogether. So although we've maybe not talked about it in a joined up way like that, that is the joined up system that I have in my head. We might be talking about.
Is that progressing? I mean, are
over the
people
next
amenable
number
to
of
this?
years. Well, all those work streams are within there. I say the ones that we're probably got most priority on are the out of court disposals, the early engagement. Say we've got a study visit to Leeds, and we're going over there with some senior member of the judiciary here and a former judge who is working on legal aid reform at the minute, and we've got DOJ coming in place. So we're all going to visit Leeds Crown Court in action, and we're going to meet with police and prosecutors as well as part of that visit. So we're not all there at the same time. We're sort of broken it up. But that one for me is a potential work stream that supports the next phase of committal reform. So you probably already know the first phase of committal reform was the abolition of oral evidence. That came into play in October 2022, I think, 17th October. And that's had a big impact. I think there's maybe been 1,000 cases go through. And unfortunately, some of the long-running terrorist cases that we've had, if there had been the right to abolish oral evidence at committal stage, might have come to court a lot quicker, because some of those cases were years in the Magistrates Court. So that is quite a positive development that has already taken place. But I think if we're going to move to the next stage of committal reform, some of the work around early engagement that I'm leading on would be a good way to prepare for that, because what we don't want, and I think I mentioned that last time, is that you cut the time it takes to get into the Crown Court, but all of a sudden the time that was spent before the case got to the Crown Court is now just accumulated in the Crown Court, and it becomes like a remand court, because once you're in the Crown Court, the costs are much more expensive. You're paying everybody Crown Court rates, and you wouldn't want it that you haven't done all the groundwork for committal reform before you would try and implement that.
The remit of the Magistrates Court's work stream is a court service lead, and that big structural piece about whether the sentencing remit should be extended, I think because it will require primary legislation, will need to be preceded by policy consultation. So I think that's the focus that's taking on. But in the meantime, they are looking at other things which might be more practical. So would there be benefit in having a road traffic court where all road traffic cases are brigaded together and dealt with quickly, and use that as a way of maybe decluttering some of the court lists? So there's a range of activities going on in that one.
But in terms of what you're leading on, it's specifically the early engagement piece, is that right?
Yep.
Okay, thank you. Just a couple more for me. Just you had mentioned the files that people are seeing, and we've learned from other partners in the system that can take its toll as people watch and see and type out. I mean, people are seeing very distressing and traumatic incidents play out, and that takes a toll. Could I ask you, Justin asked about morale, but I'm concerned about well-being and what steps are taken to ensure that your people your people's well-being is looked after? That's my first question. The next one relates to, Stephen, previously you'd articulated a view that you needed more prosecutors in order to progress things through the court. And I'm not saying that I disagree, I'm just conscious of the system as a whole. And I'm also acutely aware that the government has resources and time, and is afforded resources and time, or the state side, that the defence side isn't. And obviously the profession is under considerable pressure, they're having difficulty recruiting people and so on. So you could have a raft of prosecutors. In fact, you may indeed take some, because it's probably a more secure employment opportunity. But the private sector side is going to struggle to keep up with pace then in terms of cases. So whenever you're having these conversations, I mean, do you discuss amongst yourselves the impact on the profession and what can practically be done? Because it's one thing having a strategy, but if the defence side can't keep up, so how does all of this come together in your view?
You're right, and I'll, Chair, if it's okay, I'll deal with that second part of the question, and then Marianne can deal with the wellbeing, because that was a big part of our internal staff event last week as well. We did address them on the wellbeing, but on the second part, I'm talking about a fairly modest uplift in prosecutor numbers, and it has been in response to the increase in demand. And I do meet regularly with the other heads of prosecution services, Ireland, England and Scotland, and they have had quite significant increases in their staff. And what I am arguing for is maybe we modernise, right? So some of the reducing demand we take into account as well as increasing our headcount, because say staff are under pressure, and I'm not talking about sort of doubling the number of prosecutors or anything like that, but we haven't had any increase in headcount in years. And in fact, in 2014-15, in response to the austerity measures there, we took a number of measures to shrink the organisation, and we lost about 17% of our staff through VES. We closed about half of our offices, and at that time, whenever we were shrinking, the amount of serious crime being sent to us started to go up, and that's been consistent over 10 years. So there is a gap between where demand led, but the demand has gone up and our resources haven't kept pace. So I am not talking about going out and sort of soaking up all available legal resource.
Actually, we have a concern generally about the number of people entering the profession.
Yep.
Because what we're hearing is people going through the institute in terms of criminal law, 3. Yep. Now, that's not helping you. It's not helping the defence side. That's not helping anybody, because if everybody follows corporate,
yep.
That's not going to work for society for a long time.
We're going, part of the study visit and part of the conversations I've had previously with other DPPs, even whenever they have had the funding to increase prosecutor headcount, they've struggled to get them. So it's not just a problem here, it's a problem elsewhere. So one of the things we're looking at, if we had additional investment, is legal support officers. So they're not always fully trained lawyers, they're working alongside lawyers, because sometimes what lawyers do, there'll be an element of administrative work in it, preparing applications, perhaps ensuring victims and witnesses are kept updated. It doesn't always have to be the prosecutor, it could be somebody who's working alongside the prosecutor and is involved in that. So that's something we're looking to do as well, to ease the pressure on it. But again, I think the early engagement piece that I'm working on, the engagement with the defence, looks very different in other jurisdictions than it does here, and I am an advocate that they have to be properly resourced to engage with us, because some of the other pilot initiatives we've had where we've tried to get engagement with the defence early, it doesn't work if in a more serious case there isn't counsel involved in the case. So we can't reasonably ask a defence solicitor to engage with us about a case if they say, well, hang on, there's going to need to be senior counsel on that. I can't get involved and agree things until I have that senior counsel involved. You have to find a way to look at legal aid again, which is what currently being done, that actually incentivises that early engagement. But it is all linked to the idea that there's quite a lot of cases that do plead guilty, and if we can get to those cases earlier, that's one way of freeing resources. If we can even identify the cases that are going to need to go to trial at an earlier stage and try and narrow the issues, that's something else. We can't do it on our own. We need to do that with the defence. So I'm very conscious that it's not just about growing the PPS, and the defence then will have to keep up with that, because anything one area of the criminal justice system does has repercussions. So if the judiciary,
opposite reaction.
if the judiciary were lucky enough to get funding for another 20 judges, they couldn't just expect us in the defence to turn up at every court. So we do realise that we have to work in that collaborative way with other parts of the justice system.
That's great, thank you. I think Marianne was going to touch on the
Well-being.
well-being.
On the well-being,
Yeah, just on the well-being. So I think, well, I hope we do have a very good understanding of the impact of trauma and vicarious trauma on our staff. And we've actually now kind of identified that formally as one of our corporate risks for the future. And you know, if you think about the case types that all of our staff are dealing with, so in the serious crime unit, it's a daily diet of murder and serious sex offence cases. But across the organisation, we have indecent images of children, we have fatal accidents, and domestic violence. And I suppose there's a heightened risk because some of our staff themselves might be vulnerable through experiencing crime, and just life issues in general. So the risk is really attaching to every member of staff, in whatever way they're engaging with cases. But we do have a wellbeing strategy under development, and we do have a wealth of resources to try to support staff keep well, because we have a legal duty, but we also have a moral duty, obviously, to make sure that staff are well and can keep well. We have a mental health first aider who's a point of contact within the organisation. We have individuals called our well champions, and they're available to support staff. We have had bespoke classroom sessions for staff where we kind of educate them about some of the indicators of trauma and how best to deal with that. And there's an absolute world of online resources and seminars just to assist staff. But we have, to be honest, had a bit of a mixed response to that. It has all been offered to staff. We have had really strong uptake in some sectors and less uptake in others. So we are looking now at actually making that mandatory for staff. There's a bit of a debate about whether it's kind of forcing people down a route that might be beneficial to them, but we do have to think about how to meet our responsibilities, you know, sort of cohesively. And the message I suppose I'm trying to get out to staff is that it isn't just about the organisation presenting you with options. We need you to engage with us and actually let us know if your work is if you're just not feeling quite right, you know, you need to kind of let us know that and be confident that you can tell us and that we will deal with it and support you. So I think we're in a good place, but we haven't yet managed to get that reach out to all of the staff who would benefit from it.
I do think, obviously the civil service publishes figures for working days lost through sick absence, and the figures that we had for the last full published year, we were certainly at the wrong end of that table. We were up at the top end for working days lost. Now, part of that will be to do with the excessive caseloads. Part of that will be to do with the nature of the material, and hopefully we are beginning to address that. But it is a worrying figure that we would want to sort of try and get under control again. Similarly, people surveys are done from time to time, and the figures that are coming through it would show what one of the questions asked is whether you want to leave the organisation or not, and that figure has also gone up. So hopefully what we've done for the last 18 months to begin to pull that back will begin to pay dividends, but they are challenging situations.
We're actually just on Monday going to be speaking about staff rotation, so offering staff the opportunity to leave. So and it's kind of odd maybe in a way that the staff in the serious crime unit, very few historically, when they've had an opportunity, actually they value doing the work. They're fantastic at it, and they don't actually particularly want to leave. So it's again difficult discussions to be had. But we now have the sort of capacity to offer rotation. But then you're rotating somebody into work. You're rotating them into work where they'll be dealing with indecent images of children, other very troubling case types as well.
None of it's easy.
Mm-hmm.
No.
Did you want anything to
Just on, because it goes back to the point that was raised earlier, just around staff retention and the turnover on agency staff. So what proportion of your staff are agency and at what tiers in the organisation, and then what are the retention or turnover rates then? And is there any correlation between temporary staff in terms of agency and...
Yeah, we have a significant proportion of staff who are agency. I think we have about 20% of staff who are agency, and then we also have probably 14-15% of staff on temporary arrangements or temporary promotions. Part of that was because there was a recruitment freeze in place for quite a long time across NICS, and that would impact most administrative grades, AA and AO. The turnover at that level is probably about 5%, so it's fairly high, but it creates an additional overhead in terms of induction and training. Similarly, on the public prosecutor side of things, again, we have been, for some time, we have been without a supply list for substantive prosecutors, and that has manifested itself in terms of agency and temporary promotion arrangements. But we have now just completed a number of promotion schemes, or number of recruitment schemes for all legal grades, and we're hoping now that we've got a sort of slightly better funding settlement as well, that will allow us to get more stability back into the process. Legal grades raises a slightly different issue, because even whenever you get new staff in, there's a period of time before they can start taking decisions in their own right, and for a while they have reduced decision-making targets. So the quicker we can get stability and get people up to fully trained, the better.
Okay, thank you for that.
I thank you very much. You've been inordinately generous with your time. It's been a really interesting discussion for us. Thanks again also for putting up with us trying to change dates and so on, but things were quite difficult at a stage. We didn't want you at the same time as the Minister and the Chief Constable. That wouldn't have been ideal. But thank you very much. We're eager to follow up with you on your proportionate responses to lower level crime and things. I mean, those are interesting to us, and certainly the modernisation work is really helpful. So thank you to each of you for taking the time.
Members, appreciate it.
Thank you.
Thank you.
I'm sorry that we took some extra time there, but actually I think it was really worth it. And it's helpful to have heard that. Thank you very much. So agenda item 5 then is the budget 24-25 year and June monitoring round. We're going to have oral evidence from DOJ officials. This is at pages 22 to 84 of your packs. We're going to have a number of officials with us today to provide a briefing, so there may be a bit of changing at the top table as needed. Are they ready? Everybody, just while you're coming in and getting settled, can I thank you very much for coming and apologise sincerely for the delay. It's the first time that we've had the PPS with us. We had a really interesting conversation, and I was reluctant to curtail members' time when they were trying to follow through a line of questioning. So thank you very much for your patience, and apologies for our tardiness. Members, we have with us Hugh Wittes, the Permanent Secretary, Deborah Brown, the Director of Justice Delivery, Mark Goodfellow, the Director of Safer Communities, Sean Holland, the Director of Access to Justice, Lynn Capper, the Director of the Northern Ireland Courts and Tribunal Service, and Lorraine Montgomery, the Acting Director of Corporate Services in Reducing Offending Division. I really hope you all didn't travel together, because the whole system will go down. So thank you very much for coming again. Apologies for our lateness. I will hand over to you. We have your paper already. I'll hand over to you to give your remarks, and then presumably there'll be questions at the end. So thank you very much.
Really helpful, Chair. Thank you so much. And thank you very much for having us back. I won't reintroduce everybody because you have just done it there, but we've brought everybody along. You probably know Beverly Wall can't be with us today, but Lorraine has very kindly come from the division as well. So we thought we would provide the committee with an update on the 23-24 provisional outturn, on the 23-24 annual report and accounts, and on the final budget for the coming year. We'll also give a brief update on the June monitoring exercise in the current year as well, fairly obviously. I am going to ask Deborah to cover some of the detail of this, but before I do so, I thought I might make just a few opening remarks, Chair, if you're content. So I think everybody knows the Executive had about $1 billion to put towards pressures of $3 billion. DOJ has been allocated $95 million That's 9.9% of the available amount, despite our pressures representing 14% of the total pressures across the block. So this is, from our perspective, it's going to exacerbate a certain level of underfunding, which the department has had for some time. Just by way of context there, so over the last 13 years, the department has seen an increase of 13% on its budget. That may sound good, but the block has gone up by 53%. Health has gone up by 80%. Education has gone up by 50%. So just in terms of context, it's not a very comfortable position for the department to find itself in. We have done an allocation of the 95 million. We can talk about that shortly, but we're still facing therefore a total of 349 million of pressures. 227 million of that, I think you'll be aware of, relates to exceptional items. These are McLeod, data breach and holiday pay items, but it still leaves us with 122 million pounds worth of pressures in order just to sustain current services at current level. I thought I might say a bit about the impact of the settlement. So I'm happy to get into this in more detail with people, but it's very evident that overall this is going to have serious implications for the delivery across the department and its agencies and the wider justice family. Without additional funding, the Minister made this clear when she was here, there's real potential for lasting damage to the justice system, which we think fairly obviously would be quite regrettable. The budget settlement, there isn't a sufficiency in it in order to meet the increased demand that is facing the department. So just by way of a few examples, we have a 35% increase in prison numbers over the last 3 years. Police officers, I think you're aware, police officer numbers are at an all-time low of currently 6,394 against the New Decade New Approach recommended level of 7.5. And for example, legal aid costs have seen a 30% increase, and I think again you're aware we've got significant backlog in the courts service by the court service. So for me, that speaks to a kind of a combined effect of a certain amount of underfunding, but also dealing with the rather unique and unusual demand-led nature of the majority of the services delivered by justice organisations. So there are difficult decisions to be taken on prioritisation in order to manage these pressures and also to live within the budget allocation and to meet the requirement not to spend anything that isn't allocated by the Assembly, and in terms of accounting officer responsibilities to meet the Assembly's expectations for the money that is allocated through the budget to the department. So we have identified a number of potential actions, and happy to think through some of those later with you and so on, to reduce the funding gap. These are currently being considered by the Minister, so aren't completely decided, but fairly obviously there would be some negative impact on the system as a whole. We're also engaging with further discussions with both the Executive as needed once we get clarity on these things, and with the Department of Finance in relation to the exceptional pressures. So once it is clearer exactly what's going to happen in relation to holiday pay, McLeod injury to feelings and PSNI data breach costs, we're currently still engaged with the Department of Finance and we'll continue to do that as well. Very briefly on capital, so we bid for £122 million worth of capital. We were allocated 92, so that doesn't allow us to meet all of the pressures that we have in the department or all of the bids that we had internally, and we can provide some detail on that as well if the committee is interested. So broadly speaking, this is the most challenging budget I think I've seen departments as a whole face during my period in public service. It's going to require very careful management across all the departments, but in particular given the level of settlement that Department of Justice got in relation to us to manage and reduce the risk of any overspend. And as accounting officer, I'm quite serious about my personal responsibility in order to make sure that any overspend is avoided across the departmental accounts. Just very briefly, we've also shared the business plan with you, so that might give you a bit of a flavour. It's still in draft, fairly obviously. We don't have a programme for government as yet, and therefore there can be no kind of overarching objectives for that to feed into. And we're equally conscious of the equality requirements in relation to it, but overall it's kind of demonstrating what may be possible. There'll still be a challenging financial position, and we'll have to keep an eye on that as the plan is finalised and delivered. If that's okay, Chair, I thought I might pass over to Deborah to provide some detail on the outturn and the other issues.
Thank you. So if I just move first of all then to provisional outturn. So as you can see in your papers, the provisional outturn figures were submitted to the Department of Finance on the 14th of May. As you're aware, last year was a very challenging year for us with a budget cut of 1.7%, and we started the year with something like 148 million of projected pressures. During the year, the department did secure some funding in November, 11 million from the Secretary of State to meet some of the legal aid pressures. And then towards the end of the financial year, as you're aware, in February, the department then was allocated 75 million. Despite that quite late allocation of the 75 million, the department was able to minimise its underspend and was able to achieve our smallest non-ring-fenced resource dial underspend, both in monetary and in percentage terms. A very small underspend of 0.6 million, which is 0.05% of the department's budget. And that was because of specific actions that it took towards the end of the year to make sure it maximised all of the budget available to it, and therefore also try to minimise some of the pressures moving in to the new financial year. However, that provisional outturn is subject to the audit, and it could change, and we will of course keep you updated. In addition to that, you'll also be aware of the ICO fine that has now been levied against the PSNI, and that has not been factored into that at this point. On the capital side, we had a small underspend of 1.5 million, 1.7% compared to our budget. So you can see there that the ring-fenced resource dial provisional outturn was also 1.5 million underspent, or 1.45%. But again, all of those figures are provisional, and once they are audited, we will come back and report the final position to the committee. On the actual audit itself, the 23-24 resource accounts have been submitted to the Northern Ireland Audit Office. That was done within the timeline on the 31st of May. We are on course to meet the summer recess deadline for the laying of those accounts, and that is despite some of the very challenging staffing pressures that we are experiencing. Moving then to the 24-25 budget settlement. The Minister of Finance issued the budget allocations to the departments on the 25th of April. As she has stated, the department's non-ring-fenced resource dial budget allocation was 95 million. That's 9.9% of the total funding that was available to the executive. However, on the basis of our pressures, which were estimated at 446 million, that actually represents 14% of the total pressures. And that would have indicated that we should have received an allocation of 134 million, which is actually 39 million more than the 95 that we actually were provided with.
Deborah, you should have received how much? 134 million?
Yes, if it had been done on a pro rata based on our level of pressures, our pressures represented 14% of the total pressures. So if we had got 14% of the total availability, we should have got 134 million rather than the 95. And that allocation of 95 is only 9 million more than the funding that we received during 23-24, the 86 million, which was the 11 million for legal aid, and the 75 million that we got in February. So that's a very small marginal increase in funding against which the department is facing increasing demands for its services and inflationary costs, as well as the full year impact of the pay awards for 23-24, as well as then pay awards that will be payable in 24-25. So whilst the additional 95 million of funding is welcomed, it still leaves the department facing pressures of £351 million, but within that is 2 million of transformation bids. So leaving that aside, that's the 349 million of pressures that still remain. And just to put the perspective on that 349 million, that broadly equates to the combined spend across prisons, courts and tribunals, legal aid and the core department, whose annual spend is usually around about 369 million. So the department then had to make a number of assumptions and considered various options for allocating that 95 million across the business areas. This was vital, as the Minister was very clear that the allocation should be based on the most equitable and fair basis for all of our organisations. And this is particularly important for the justice system, given the consequential impact that funding decisions in one area may have on other areas of the department. So a pro rata allocation based on the stabilisation pressures, that is excluding the exceptional pressures to do with the data breach, McLeod and the holiday pay, was determined as being the most appropriate option to provide the most equitable distribution of the available allocation across the core department, its agencies and the non-departmental public bodies. This option was approved by the Minister and the opening allocations were communicated to the Department's business areas on the 21st of May. The Department is currently considering what actions are now required to live within the resource allocations, as this falls significantly short of what is required, which means that extremely difficult decisions will be required to remain within that resource budget. I'd also highlight that all of those allocations are now draft until we have completed our equality screening. Moving then to the capital, the Department's capital allocation was 92 million. That was a shortfall of 30 million or 25% against our total bids of 122 million for our inescapable and our high priority projects. The Minister approved that we would allocate 100% to the inescapable bids, together with 30% of the bids that were submitted for the high priority projects. So then just moving then to June monitoring and the in-year position. The Department of Finance issued its in-year monitoring guidance on the 10th of May and included a return date of the 31st of May. The exercise was formally commissioned by DOF on the 21st of May. Given that very short time scale for us to complete the June monitoring, it wasn't possible for all business areas to completely reassess all of their pressures in light of the new budget allocations. So the Department submitted bids to DOF for June monitoring to the full value of the 349 million, which represents all of the pressures across the board and also takes account of the 95 million allocation and excludes, as I said, the 2 million of transformation bids. Transformation bids is now being considered as a standalone exercise. We also had requested 1.1 million from the Northern Ireland Consolidated Fund, and we have submitted bids of 18.7 million for ring-fenced resource DEL pressures and 17.4 for the capital DEL pressures. The June
just slow down that one. So 1.1 million from the Consolidated Fund. What were the next two, please?
And then there's 18.7 million for ring-fenced resource DEL, so that's things like your depreciation. And then 17.4 million for capital DEL pressures.
Okay.
So the June monitoring details have been shared with the committee and the outcome is not yet known and it is not clear when June monitoring will be presented to the executive, and indeed it may have to wait until after the election. DOF has indicated that there may be some funding available in June monitoring around Barnett consequentials and some of the negotiations that were had around the 124%. But again, that remains unclear as to how much might be available. So in the meantime, while we await the outcome of that, business areas have been advised that they must manage their spending plans in line with those opening budget allocations, and that there should be no assumption that there will be further allocations in monitoring rounds. And until then, the Department will continue to monitor its position on a monthly basis, and we will then conduct a full exercise for the next monitoring round in October. Just to give you a little bit of information then on the transformation bids, as I had outlined earlier, we had previously put forward a number of small bids, but subsequently now there has been a new exercise commissioned. So the executive had agreed to the creation of an interim board to consider the administration and the prioritisation of the 235 million public sector transformation fund, which begins in 24-25. Subsequently, the interim public sector transformation board, chaired by the head of the civil service, has written to the departments to officially call for those proposals. £47 million is available for each of the 5 years, and the bids are to be returned to DOF by tomorrow. The request is for a maximum of 6 proposals per department, 2 large-scale proposals in the range of 10 to 100 million, and up to another 4 small-scale projects below the £10 million. So we are currently finalising our proposals. Our proposals include 2 large bids, one around speeding up justice, and another for reducing harm from domestic and sexual abuse. And then we have 2 small bids, one which is to reduce the pressures on our prison population, and another to take forward the technology on electronic monitoring. In addition, a bid will also be submitted from the Tackling Paramilitarism team. This will be a large bid, and this is for a violence and harm reduction hub. Once those proposals are finalised and approved by the Minister, we will provide the further details to the committee. So in conclusion, I hope I have provided a useful overview of where we are now in terms of our financial position. While we continue to operate in a very uncertain financial environment, the Department's position remains extremely challenging in managing this budget. I'd like to thank you all for the opportunity to brief you today. We very much value your role and the views of the committee in helping us with this very challenging position, and we're happy to take any questions. And if there's any questions that we can't take, we will of course take them away and come back. Thank you.
Well, thank you very much for this. You say uncertain. I just think it's bleak, actually, when you hear. I have Doug first of all, please. No? Deirdre?
Well, you answered my last question on the transformation bid, so you'll just give or send them through then an update once the Minister's approved. No, that's good then. I was going to ask, are any of those done with other departments in collaboration? Because one of my questions was going to be around the disjoint within the system and the justice family even as a whole, and obviously that correlation with health that comes up on a regular basis in terms of prevention. So it's just, are there going to be some of the larger bids or the smaller bids in transformation that you're working with other departments on?
Both of the large bids are cross-departmental, so speeding up justice is across the criminal justice, includes PPS. Just with you, ending violence against women and girls is our part, but as an integrated kind of whole with the TEO, ending violence against women and girls policy. The violence and harm reduction one, that's EPOC, which is actually an executive programme. Still kind of exploring just as to how exactly that'll be treated, because it's not purely there for a DOJ issue, it's an executive programme. And on the other two, electronic monitoring, Mark?
Electronic monitoring, it's not a cross-departmental bid, but we would see there being clear benefits downstream, clearly right across the justice system and beyond, including to partners like Probation Board and others around that community supervision piece.
Okay, thank you.
Prison populations.
Yeah, in terms of prisons, certainly there's some work going on in terms of working with partners. Again, probation in terms of trying to support those who are on short sentences, and certainly trying to improve the effectiveness of the rehabilitation work that's happening behind the gate.
Yeah. Okay.
We're very clear. Sorry, Deborah.
Sorry, the reducing harm, domestic and sexual abuse one is being countersigned by the Department of Health's Permanent Secretary as well, so it will have that support.
We're very clear
that
everything the department does is so integrated with everything the other departments do, and that their products their policies very often kind of push people towards us, and vice versa, that we have maximum impact when we're collaborating like that.
I know, because it'll be an area for the committee, because it's consistently coming up, and even the visit to McGabry last week again. So, and I think we may go back to look at some of the prevention and intervention work there as well. The other bit was just around, the budget overall, and around further work obviously that's being done in terms of linking it to the strategic priorities you're saying around the business plan, obviously the programme for government. So it's just around if we can be provided with further information then, once those processes have been completed. I was going to ask then around, is a fully QIA being done? Is it out for consultation at the minute? I know DFC's opened, I think it was the 11th of June, and it's running to September. And my understanding is then October monitoring will begin to look at some of these in terms of EQIA pressures or things that may come up. So it's just from this department, and also by way of the budget, are there going to be areas, I know we'll get more information, around what actions you're going to be looking at, or the Minister's looking at to reduce the pressure, but are there going to be some areas that you're going to move at risk with the hope that you'll get some in-year funding to address, and if so, can you say those areas at the minute?
In terms of equality, so we would treat all the allocations as draft at the moment, and we are working through the screening process in relation to that. But if the screening suggests we need to do an impact assessment, then we will, and that'll be published as normal. On the forgive me, the first one, remember? I got the third one was about going at risk
Yes.
in terms of allocations. Well, we're still working through with the minister exactly. So we've come to various conclusions about where, for example, money might be saved. None of it is particularly attractive in terms of either delivering on the objectives of the department or positive outcomes for example, prison population or PSNI services, etc. So we're working through those with her. In terms of going at risk and the expectation that there might be more money later in the year, my impression is that after June monitoring, there's not going to be a lot of extra money. So I would be quite resistant to taking much risk in the sense of predicting or guessing that we might get extra money in year, but we will keep that under review as the year progresses. Sorry, Deborah.
Yeah, and whilst there's not a lot of hope around getting additional funding in year, this department has demonstrated that when it does get additional funding, it has been able to spend it, and indeed towards the end of the 23-24 year, that was a deliberate strategic approach that we took around getting money out the door and on a weekly basis monitoring our spend and finding out where there were potentially some underspends. And so we put money out through Compensation Service and legal aid, which then has helped to reduce the backlog on legal aid, which allows us to start the position in a slightly better position, albeit still a backlog of 11 weeks on legal aid that we opened April with. But again, if we get money, we know that we have areas that we can get it spent. There are areas of the department where pulling back on spend is incredibly difficult because the majority of the spend is on staffing, and so achieving some savings in year is very, very difficult for this department.
We've focused a bit as well on the stabilisation pressures, and there are still 122 of them, but beyond that there's the 227 pressure for the exceptional costs, so that I'd have to factor that into the risk calculation as we move on as well, if any extra money is available.
I just, when the screening will be finished then, and will that be made available to us in terms of the outcomes? Is there a rough time when that will be done?
We had expected all returns to be in this week, but unfortunately we've got a couple of business areas that just haven't been able to meet that, so we've had to give them a little bit of extra time. So we were hoping to get something out, sort of the start of July, but given the couple of delays that we have, a couple of the larger business areas, that might not be possible, but that's our...
You can keep us updated.
Absolutely.
But okay, thank you.
Stuart?
Yeah, thank you. I mean, very tough decisions to be made. Very pleased and rightly so to hear the Permanent Secretary say that as accounting officer he takes this as a very personal responsibility to ensure that every penny that's spent is spent wisely, correctly, and that we don't do things that we shouldn't be doing. I think that's a very strong and positive lead from the Permanent Secretary. Can I ask two questions? One, you said obviously there are pressures that are pushed towards you by other departments, programmes, and the cooperation levels between departments to recognise both short, medium and long-term issues that ultimately end up, and we see that regularly in the prison service, and some of that goes back to early years of someone's life. What plans do you have to push away those pressures? How are you working with other departments to say, if only we did these things together, short, medium and long term, then we would have very different outcomes? What's the level of cross-departmental working on that on a practical level?
So EPOC and the Tackling Paramilitarism programme might be a good example there. I might ask colleagues if they have others as well, but broadly speaking, it's identifying the factors, A, in terms of the way paramilitary organisations work and take advantage, but also B, the way individuals are vulnerable or communities are vulnerable to the interface with paramilitarism and so on. So that whole programme, there's very little of that is actually delivered inside DOJ. That's working with TEO, it's working with voluntary partners, it's working in communities, it's working with the police as well, in order to cooperate across the whole system to prevent people being drawn into paramilitarism. That's one way that is done, and similarly then with other interventions as well. Mark?
Yeah, just to extend Hugh to what you've said and to pick up your point, Stuart, I think we're in a place where the fiscal environment is driving us that we can't afford not to collaborate to get the right outcomes. So a couple of examples on my side, and I mentioned this the last time I was in front of the committee. The Minister has agreed to develop a new community safety strategy for Northern Ireland. That, for me, the worst outcome is if that's a DOJ strategy and a DOJ strategy alone. because we know the safety of communities, and you referenced prison population. It is quite often those socio-economic factors that drive people to the attention of the criminal justice system. So if we can get upstream with communities, with health, with education, to get the early interventions right, that can only benefit individuals more importantly, but from our perspective in the justice system. So that's got to be a truly collaborative impact. Likewise, we have a one-year addendum for organised crime. We need a new strategic approach to organised crime, but I don't think that should be in isolation of a wider, safer communities strategy. So there are opportunities there to streamline, and again, we can't do that unless we take a trauma-informed and a health-informed approach to that. There's some very specific points I know we won't have time to go on to, but the prevalence of mental health within the justice system is of increasing concern, and we see that every day. So we're working directly with the mental health champion on a number of initiatives. We're supporting PSNI and Department of Health at looking at a programme called Right Care, Right Person, just to make sure that we're getting the balance right between the operational, very intensive resources that the PSNI are having to do, often to be first responders in a health space. So working to try and drive out some efficiencies there as well.
Moving then to the transformation budget, which I think will be very helpful going forward. How, and maybe this isn't a question for you, but more a question for those who are actually leading the transformation board. How can we be assured that all of the bids going in will be bids that are genuinely needed by the proposers, and that they're not simply just pet projects?
Well, you might have to ask other departments about that. Yes. There's none of that coming from our department. So these are genuine transformation attempts. The system is designed to there's a multi-stage system, so it's designed to filter out bids which, for example, don't show enough invest to save, won't be sufficiently aligned to programme for government objectives, etc., and then ultimately be put up to the board. And the board will try and select those which seem to show best return for the entire system in Northern Ireland, and ultimately then it will go to the executive for approval via the finance minister, I think.
I suppose the other side of that question is, what penalties would you face if, despite getting a project through, that it failed? Is there an incentive on you to ensure that what you present to the transformation board and what gets approved is actually sharpened and honed to the point of delivery?
So again, I would say that ours are, and there's a stage after this. If you get through it, then we'll have to work up business cases and full kind of project plan development for each of them and so on. In terms of a penalty, and especially a penalty for failing and so on,
yes,
I would prefer to be in the territory where we try things that we genuinely think are good investments to try and improve. If mistakes are made, or if it doesn't yield the returns that we had hoped it might, in whatever the outcome might be, like reducing offending, for example, then we learn from that. So I would think more not in terms of penalty, but actually, right, how can we make this better next time? And again, the programmes that the department has sponsored and been involved in are exactly that. So the EPOC type programme is very heavily kind of data informed about the outcomes of the projects and interventions that we've tried, and we have learned from those in terms of putting in our bids, and I'm sure other departments are doing that as well.
And will there be external assessment of those transformation projects?
Again, my understanding of this, it's a DOF asking for the bids to be in and so on, but my understanding is that the Transformation Board has an independent member on it, so it'll be the head of the service, and it's one of the independent board members from the Civil Service Board, and then there's UKG representation as well.
Thank you, Chair.
Thanks, folks. What percentage of the budget is spent on the PSNI data breach and the McLeod injury to feelings?
In 23-24, there was a small amount in PSNI in relation to
6 million was spent on the data breach, and then in the exceptional pressures is 116 million for the data breach, which is the PSNI's estimation about how much those claims will cost. So there's no certainty yet on that.
Those haven't been factored in yet, though, have they?
They're in the 227 million.
The piece that hasn't been factored in is maybe the ICO fine.
Yes, the
that was
ICO
levied
fine
against the
hasn't
data
been
breach of 750k.
There's a window for PSNI to make representations to the ICO in relation to the quantity of that.
Yeah. And then there's 30 million, which is for McLeod, and then there's 81 million is on holiday pay.
So the 116 million, just explain it to me, that's over a period of how long is that expected to be?
That is our estimation. That's the estimation from the PSNI as to how much the claims will be on the data breach.
Okay,
As to
total.
when that will be settled, still has an element of uncertainty around it. We're currently awaiting a business case to come in from PSNI on that.
And in relation to the 30 million McLeod, is that an estimation as well?
Yes, that is an estimation at this point, yeah.
And is that not a huge worry from in terms of efficiencies that departmental spend will extend to such a degree based on failings within?
Absolutely, and that's why we've set the 227 million aside for the time being, and we are in discussions with DOF, and holiday pay and McLeod are not just a DOJ issue, they are across all the departments, so there will have to be an NICS solution to that. And we've been very clear whenever we've been engaging with DOF that for the time being we've had to set those aside because there is no way that this department could do anything to manage the size of those pressures.
In terms of capital, where does disposal of vacated properties sit on the capital budget?
So we don't have any proposed disposals during the 24-25 year.
Why not?
We're currently drafting up our asset management plan. Our asset management plan looks to ensure that we're maxing the use of the DOJ estate, making sure that we're keeping regular review of our leases and using the estate to best effect. But there's no actual disposals of any size that are projected in 24-25.
The modernisation of the infrastructure is totally necessary. Cross Glen, as part of the South Armagh Police Review, has been agreed to be disposed of. And why? What's the delay in that? I'm sure that's an answer, that's a question for the Minister as opposed to you. So, and also, I have other questions for the Minister, which I'll table to her whenever she's before us again. So, thank you very much for your time today.
I suppose, folks, just if I may, I have a few bits and pieces here. Are you giving consideration to things not going ahead? And how are you, because it seems to me you've got no option but to consider things will not proceed. So what's in the ballpark there is what I'm asking you. What consideration is being given to that? How are you going to prioritise what you're doing? I appreciate you've moved to kind of stabilise and be equitable with that, but there are still within that going to have to be tough decisions made because, for example, if somebody's putting in a bid for capital and they're only getting a fraction of it, it's not going to be able to proceed. So, you know, how are you prioritising what will go ahead and what will not? As yet, we're still waiting for a PFG, so there'll be priorities within that may change your priorities. So, what flexibility has been built in there when you're really up against it and have very little room to manoeuvre as it already is? And I suppose a couple of other things then for me, which are, we've seen your business plan and there's a lot of references to various strategies and so on, and strategies are all great, but you need to have the money to implement them, and it seems to me you don't really. So we've also heard from the Tackling Paramilitarism programme about the extent of duplication of strategies across the civil service. Something like 80, that no central department keeps a record of the strategies that currently exist in Northern Ireland, which I find shocking and abominable, to be honest, in these financial straits in which we find ourselves. So within all of that, I have sought from the Minister down to establish the extent of collaborative working with health. And we are familiar with the collaborative working within the Tackling Paramilitarism programme, but we cannot ascertain in any meaningful way the extent of the collaboration beyond projects here and there. And I think we're at a point now where the duplication within departments, the duplication in strategies and priorities without collaboration can no longer proceed. So if there is some way that you can give us information around the extent of the collaborative working between health and justice, it would be really helpful, because frankly we're well aware that there's massive overlap in terms of the problems. Therefore there needs to be considerable overlap in terms of the solutions found, and it seems to me all the time it's presented at justice's door, and that should be the last resort. So that's it for me. What's not going ahead? How are you going to prioritise? How are you going to fit in PFG priorities? How are you going to resolve duplication? And can you give us information around meaningful explanations around collaboration?
So we can, on that last Chair, we can definitely, we'll follow up with maybe something more fulsome. But for example, health trust in prisons. Lorraine, do you want to just say a word there, just as an example, Chair?
Well, see, Hugh, that's the thing. We're familiar with those examples, but we're also familiar with how they don't work to an extent. So, for example, we're aware that the healthcare in prisons has been contracted out to trusts, but we also know that within that there comes difficulties in terms of the prescription drug issues within prisons, because prisons then can't be told, because of patient confidentiality, how much medication a prisoner holds for themselves, what their baseline is for that medication, what they've got. I mean, so for each move on the chessboard, there's another series of reactions that can't be resolved because of resourcing. So those examples we're familiar with, but now I'm talking, not individual projects, strategically now. I think there needs to be collaboration to resolve the issues, and I'm not seeing it. I can't even get to grips with the extent of the conversations between the ministers, about the subject areas even that are being looked at. But we're reaching that point now where I think we need hard facts and not kind of examples way down the chain. At the highest level, what is going on between the departments to try and root out duplication and to work more collaboratively.
Well, maybe we'll come back to you in some detail on that then, Chair, if that's the way to address that one. In terms of prioritising, so on the capital, I don't know if you just meant the capital side, but I'll do both. On the capital side, we were able to fund all of the inescapable commitments this year, and then we did essentially a kind of a pro rata for what other people needed, with a few tweaks around the edges. I might ask Deborah to say a bit more about that if you want to hear some detail. And on the business plan, we absolutely recognise that the business plan is maybe not as ambitious as it could be if, for example, we'd got the kind of level of funding that Deborah had suggested would be equivalent as our share, as a perfectly proportionate share of the money available, or if the financial position this year wasn't 3 billion pressures for 1 billion across all the departments. So we recognise that there's kind of less, I hesitate to say less ambition, but maybe less kind of successful delivery which is available this year, so we have scaled that back a bit.
Yes, absolutely.
It is also absolutely draft, so not totally approved inside the department yet. Minister's still looking at it and so on, but also until the PFG is formed, it'd be precipitate of a minister or a department to come up with a definitive plan. But again, we can't sit around waiting indefinitely for that, so the idea is that we get to where we think we might be. If it needs serious adjustment after PFG is agreed, there will be serious adjustments, that's okay. And also then as we look at it as we go through the year, and as funding and as we work through the pressures of the 122 and the 227, we may well have to adjust it again, or adjust expectations about what can be delivered, possibly upwards, probably more likely downwards, but we will continue as a department to do absolutely everything we can in relation to it. Sorry, Deborah, anything to add?
Maybe
to
just on the capital, some of the reassurance around it is this capital allocation allows us to take forward a number of key strategic projects, which will help with the cross-departmental elements. Specifically Causeway, we'll be able to commence with that. We've got our big project Atlas down in Fisney, and we've got the Themis project as well. Those could then be further maximised by some of the transformation bids that we've put up on the speeding up access to justice piece. And then we'll also be able to start to look at some of the modernisation that is needed on the estate, the prison estate. So looking to start on our new facility for the women at Hyde Bank, the new visits at Magabry, and the reconfiguration of McGilligan. And just back on some of the issues about what we're stopping or whatever, obviously those decisions are yet to be taken, but We do take forward a number of projects on behalf of other departments, and indeed those are areas that we are going to have to look at critically at, because if we're unable to do even our own things and other departments are not providing the necessary funding, then there could be very difficult decisions in there as well. But all of those at the moment are with the Minister for her consideration.
And beyond the capital?
So within the prioritisation, obviously we had to look at what was inescapable around all of the business areas. We then looked at where people were reporting the pressures. We looked at different options to allocate that 95 million. So we looked at what people's baseline was, and we could have allocated on that. That didn't really take account of the true pressures. We looked at where the pressures were sitting, and we took the decision to take the exceptional pressures out because we need to park those for the time being. And we also took out the elements around the consolidated fund money that we expect to get in June monitoring round, and also some of the additional costs around legacy, because there's so much uncertainty with that. That was deemed to be the preferred option. We also looked at what was spent in previous years, but again, that wasn't a terribly fair way in which to allocate that, because some areas had really pulled back on their spend and actually had nowhere else to go, and some others might have had a little bit more opportunities in there. So focusing on the pressures, and that's why the 95 million went into the various areas. Now we're left with the situation that we have the 349 million of pressures, 120 of two of that being the stabilisation pressures. Of that 122, 34 million of that sits in the department. And at the moment, a significant element of that, of course, is legal aid. In order to stop us overspending, legal aid has always been our go-to, but we hope that we might secure some more funding in monitoring rounds in order to get the legal aid funding. And as a consequence of that, then we made sure that we had some more funding going into the prisons because of the increased population numbers, and into the courts, because again we've made so much investment in the courts. We do not want to take a back step, but also knowing that there's truly inescapable pressures in there as well, because it's around staffing. That still leaves us shortfalls in all of those areas, and there are still tough decisions that are being considered at the moment as to how we might manage that. And I still remain optimistic that there might be something that we get in June monitoring round which will help in some way.
I understand, and the difficulty is legal aid can't always be your go-to.
No, I absolutely agree. But whenever you are an accounting officer and you're told you cannot overspend,
yes,
that's the only place that you can go to, and we find it truly unacceptable that that's the position that we are in. But we did ensure that they started off the new financial year with an 8% uplift in what they had previously, and we hope that again, because it is demand led and we have a proven track record around our forecasting on that in monitoring rounds we might secure some success. And absolutely moving forward, and if we get a 3-year budget, maybe when a new administration or the administration exists, whatever, if we move into 3-year budgets, we absolutely need to make sure that we are getting the right baseline for legal aid and not having to live the way we have done over the past number of years, using it to flex the budget overall.
So our fear, I think, is that the businesses will be lost, criminal defence will be lost, and then there's no access to justice for people. Because I'm not sure of any other circumstance where people have a 12-week lag in payment, potentially for work they've done the previous year, never mind within that period. So, I mean, we're conscious of that too, that trying to get people into that profession to deal with criminal defence is horrendous, and all of these things have a knock-on factor.
I would agree with that, Chair, and absolutely to take the point about impact on individual practices and impact on individual citizens involved in the justice system. We bid for 27 million this year as part of a 2-year programme in order to get back to a 4-week payment period. We didn't get it in whole from the executive. Deborah's just outlined how we can try and manage that to the best possible degree and so on, and we've actually bid again in the June monitoring for it as well. And we will continue to push for that to be properly funded.
No, I mean,
it is absolutely demand-led, but not fully funded, therefore.
No, I mean, and we fully understand the position in which the department finds itself. We each have stood in the chamber to advocate for the department and its budget. We'll continue to do that. We recognise the severity of the situation. Assurances beyond that, I'm afraid I cannot give, but we're grateful to you for taking the time. Does anybody else have anything else? No. Is there anything else that you need us to know or want us to know?
No, that's been really helpful, Chair. I think I'll just double check with colleagues maybe who didn't. No, Chair, that's incredibly helpful, and thank you so much for the support.
No, thank you, and apologies for having kept you waiting.
Not at all, no problem. All right, thank you, members.
Thank you. We'll do our best. And we know you will too. Thank you. Members, could I ask you to turn to pages 85 to 96 of your meeting pack? We're on to agenda item 6. This relates to a draft statutory rule, the damages process for setting rate of return regulations, Northern Ireland 2024. Yay.
Favourite subject.
It's like we discussed this.
This feels interminable. Right, so members, just by way of recap, the statutory rule is going to make changes to the statutory methodology by which the government actuary has set the personal injury discount rate for Northern Ireland. The changes to be made are as follows. A, to prescribe annual weekly earnings instead of the retail prices index as the measure to be used in allowing for the impact of inflation, and B, to modify the standard adjustment for the impact of taxation and the cost of investment advice and management from 0.75% to 1.25%. At our last meeting on the 30th of May, the committee unanimously agreed that it was content with the proposal for the statutory rule. Now that was caveated, so we wrote to the department to outline a number of concerns. The committee also agreed to publish on its website all the documentation that it had considered for the statutory rule, alongside the Hansard transcripts of 2 evidence sessions, and this has now been published. The department has confirmed that there have been no changes to the policy content since the proposal was considered by the committee. The draft damages process for setting rate of return regulations Northern Ireland 2024 were laid in the Business Office on the 3rd of June 2024. The Examiner of Statutory Rules has raised no concerns regarding the technical aspects of the rule in her report that was published on the 11th of June, which can be found at pages 3 to 11 of your tabled pack. So, do members have any comments, or are you content with the statutory rule, bearing in mind all of the issues that we raised last week and put in writing?
Content.
Justin?
I think we all have concerns about insurance premiums,
yes,
in the north being the highest on these islands.
Yes.
I've big concerns for my constituents, especially BT35. Some people can't get policies, but the premiums for car insurance and for home insurance are extortionate and unaffordable in many instances. But however, on the premise that the financial impact on defendants' compensators is not relevant to how the rate is set, as the purpose of the discount rate is to give effect to the legal principle of 100% compensation, I don't think we can challenge that, but we can qualify it by saying something has to be done about insurance costs in the north, especially in my constituency near Armagh and BT35 in particular.
You can say that, the rest of us will be concerned about our own BTs. But no, look, I think that's fair, and I think that we have made those points week in and week out. The issue here is 100% compensation. We've taken advice, we have laid out our fears, we have laid out some concerns and some proposals that we hope the department will take forward as we progress in this. Beyond that, I'm not sure there's much else that we can do. So, I mean, we've been very clear what our issues have been throughout, and the issues with which we have wrestled, actually, to come to the determination. So,
perhaps not for us, Chair, but perhaps an inquiry into the insurance industry might be a better and more profitable route to go down. And I think you'll find that the implications of this in respect of insurance is infinitesimal in comparison to their profit models.
yes, and still leaves our constituents in the same position. Right. So, on that basis, I'm going to put the question. I know it's not ideal for any of us, but I'm going to put the question that the Committee for Justice considered draft SR, the damages process for setting rate of return regulations Northern Ireland 2024, and recommends that it be approved by the Assembly. Obviously, I will outline the views of the committee in the debate in the statute, which has been scheduled for the 17th of June, and that will include all the issues that we've raised. So, our members agreed with the question?
Agreed.
Thank you.
To highlight the
issues.
Yes, I mean, we know that it's with reluctance, but we're in the situation we're in. We've sought advice from every avenue possible. Thank you. Agenda item 7 is an SL1 for the Police Pensions Remediable Service Amendment Regulations. So I'd ask you to turn to pages 97 to 109 of your packs. The Department proposes to bring forward a statutory rule under the Public Service Pensions Act Northern Ireland 2014 and the Public Service Pensions and Judicial Offices Act 2022. The purpose of the statutory rule is to further support the scheme manager and pension administrator to effectively deliver the MacLeod retrospective remedy and to correct omissions and minor drafting errors. The rule will be subject to the negative resolution procedure. Are members content, or do you require any further information or clarification?
Content.
Thank you. Agenda item 8 is the Department of Justice Business Plan 2024-2025, and that's a written paper you'll find at pages 12 to 50 of your tabled pack. The Department has provided a draft corporate and business plan for the financial year 24-25. And the Department has advised that this draft plan is subject to change, especially given what the Department has described as its challenging budgetary settlement for 2024-25. The Department has also advised that the draft plan will be subject to formal consideration when a programme for government is agreed, and we heard evidence to that effect. Are members content to note the paper?
Noted, yeah, and we'll
Thank you.
note the outcome of the other.
Agenda item 9 is Access NI Annual Performance Report, which is also a written paper. You'll find that at pages 111 to 140 of your meeting pack. The Department has provided a copy of Access NI's Performance and Activity Report for 2023-24. Are you content to note the paper?
Noted.
Thank you. Agenda item 10 is the Forward Work Programme, and an updated Forward Work Programme is at pages 141 to 144 of your pack. Oral evidence on the proposed modernisation of Justice Bill session that was scheduled for the 27th of June will no longer take place, as second stage is not going to take place prior to the summer recess. Let me just check this. An oral evidence session for the meeting of the 27th. Yes, there had been a proposal with regard to the oral evidence from Sajini. But Sajini is not available. I'm also conscious that it is a week before the general election. We had heard from Sajini relatively recently anyway, and it seems to me that since members are out literally morning, noon and night in the course of a campaign, and we're a week in advance of an election by that point, I'm not clear of the merits of extending the agenda unless it were to be items of value and necessity. Deirdre?
Just a couple of things on the Forward Work Programme. Just firstly, I would agree with that in terms of the agenda for the 27th. Just in terms of if it's just the SL1s and stuff, then that's fair enough without trying to put anything else in. I think the other bit around, the court visit next week, what time? Have we got details of that? And then the other bit was obviously we had our planning day. I think in terms of September, I know we'll hopefully have the legislation and stuff coming through and being laid, and we'll be busy with that. But we did discuss areas of work that we would like to direct the committee to look at. So I think if it was okay if we kind of, set with the clerks and stuff on the committee, even as chair and vice chair, to kind of go through and look at a work programme from September, say, to Christmas, and then to get the consent of the committee in terms of areas that we'll want to focus on and getting the department in, whilst also doing the legislation. And I suppose any engagements then with outside bodies, just seeing as we were sitting here coming in, the Children's Commissioner, and I know there's others. So even if we can do some of them over the summer or whatever to try and knock some of them out, but obviously if we can just start, that we can direct the work programme over the next period and just get the consensus of the committee on the back of the planning day that we had, particularly even around post-scrutiny of previous legislation. So netting that in, and maybe other areas of work that we do want to focus on as a committee, but obviously to get the agreement of members in the room and stuff.
So a few things there. The first is the meeting of the 27th of June. Are we content that unless anything is necessary to be added in, it's not, and we're happy enough with the agenda for that day? Thank you. The other issue around the visit next week, Deirdre will come to, if that's okay with you. It's in the correspondence. In terms of the Forward Work Programme, then, are members content that the Vice Chair and I would meet with the clerks and try and establish a Forward Work Programme from September to Christmas?
That would be extremely helpful and the practical way to do things.
And also then,
The
I suppose
back
the
of our
last issue
plan
there was
session,
that
like, yeah.
Caroline, the Vice Chair and I are conscious that there are a number of requests for meetings that have been difficult to facilitate in the course of Mondays and Tuesdays and with our diaries for the rest of the week. So we'd had a conversation about maybe that a better approach might be that if the two of us take a day or 2 days and just meet all of the people who want to meet us and get through those, so that, you know, rather than stagger them, we just take the time, set it aside in the summer recess period and meet with those who are seeking to converse with us. Are members content with that approach?
And we can update the
Yeah,
committee
and then we'll
in
update the
September.
committee, of course, accordingly. Right, agenda item 11 is correspondence. So there's a correspondence memo and 18 items at pages 145 to 350. I'm going to draw your attention to a number of the items and then we'll have an opportunity to comment on any other items of correspondence in which any of us have a particular interest. The first item I'm going to draw your attention to is at page 152, and that is the visit to the Courts and Tribunals Service. Obviously there's a lot of effort goes into these visits. Members haven't confirmed yet with committee staff if it's their intention to attend. So if we're not going to have a good turnout, it might be better to reschedule that. Are people going to be there, or how are people fixed?
My aim's always to go, but things just drag us away in a different direction. It's just a bad time. And, you know, I would rather delay it.
I know the McGarry visit last week, I was conscious it was only us that attended as well, so, and it doesn't give the rest, it's not reflective of the committee, so if it is the thing of the election, then it's maybe to put it back until.
I think I'll be helpful. I've already given my apologies for that, and as far as the prison visits are concerned, I've already done those prison visits and felt that was not unreasonable. I would like to do the courts and tribunal visits, so a delay would be helpful.
Okay, are members content with that then? We'll put that off until September or somewhere thereabouts. I think I don't want them to put in the effort then. I mean, and to be honest, I was absolutely gutted at not being able to attend the McGarry visit. It wasn't until an emergency arose on the day, and I was really disappointed because I've now visited McGilligan and Hydebank, so it would have completed the set and given me a full feel. So I was really disappointed, and apologies to those concerned. I'd be grateful, could we write to the Director General of Prisons and thank her and ask her to pass on our thanks to each of the governors for facilitating. It wasn't just the committee, but it was also at the time the justice spokespersons of the parties, and they were excellent visits, and we know that it puts them to a great deal of trouble. So
Sorry,
yes,
Chair, I know just on that, because the McGarry one, so I know there was a discussion last week after we'd done the kind of walkabout around looking at the rehabilitation. So there may be a future visit that we can discuss in September in terms of the work programme, but I'm also conscious of the, it was on the news yesterday in terms of McGarry around a certain case as well. So maybe we can just pick that up going forward around an inquest and some concerns that come out of it. Now I know there was an ombudsman's report and stuff put into it where there was a relating to a suicide, a death in the prison, but just concerns around the inquest here and what came out of it yesterday as well pertaining to the McGarry prison. As say have been subject to a ombudsman's report. There's obviously been other recommendations as well, but maybe we can pick that up when we're looking at McGarry again in terms of rehabilitation and kind of broader issues.
yeah, I think we'll note that down.
And it's the link in, sorry, with health, because I think that's part of the issue as well, the siloed kind of working. One of the issues come up even in McGarry is around the dispensing of drugs, and that maybe not even the prison officers kind of know all the details of what's being dispensed and what's not.
Well, see, they're not allowed to know, and that's the point that I've been trying to make, that every time we hear this.
Yep.
So yeah, the prison officers have no idea.
I think they get into a bit more of the detail then when we get back after, you know, the kind of summer of some of this.
Yeah, that's useful. The other thing we actually need to make a decision on is around the PPS has suggested coming every 6 months. I'm not sure, would we need them every 6 months, or, I mean, maybe an as and when with at least once a year?
At least once a year, and unless some other. But and the problem is, if a particular problem comes up, it's likely something they're not going to want to be able to talk to us about anyway. So,
Indeed.
yeah. think
But it's still, it's helpful for them, and even to advise us in terms of
Yeah.
legislation, that's useful. Okay, the next thing that I have on my list is correspondence item 6, which is a response from the department to the committee following the Independent Monitoring Board for Prisons oral evidence session on the 16th of May, and that's at pages 162 to 165. Are we content to note this item and forward the response on to the IMB?
Yeah.
Thank you. Correspondence item 9 is a response from the department to the committee at pages 176 and 77 regarding the Family Drugs and Alcohol Courts pilot. I would ask you to note this item and consider the issue further when the evaluation has been completed. Content? Yes?
Yep.
Thank you. Item 10 is correspondence from the department to the committee at pages 178 to 210 following the judicial review of the Justice, Sexual Offences and Trafficking Victims Act 2022. The full judgment is included with the correspondence, and the Minister has advised the committee that she's going to study the judgment in conjunction with the department's legal team before deciding on next steps. The proposal here is to note this item and consider writing to the department to request that the Minister updates the committee regarding decisions on the way forward before summer recess. Is she going to make a decision on that before summer recess? Is it likely the Minister will have?
She's to make it by mid-July. She'll have to have made it before.
just to me before the right to seek a review.
So we would
An
need to know,
appeal.
but I think she has to make a call before mid-July. If she doesn't tell us before recess, then she'll make the decision without us being informed.
Right, so we'll stick with that then. So members are agreed to that, yes? Thank you. Item 11 is correspondence again from the department, pages 318 to page 322, and it's a copy of the Youth Justice Agency business plan. Are we agreed to note this item and consider scheduling an oral evidence session with the Youth Justice Agency in autumn winter to provide an update on progress?
Yep.
Do we want that to be oral?
Yeah, I think we probably do on youth justice.
Yeah, I think it'd be useful.
That's all right. Item 14 is correspondence, well, it's a response from the Department of Health to the committee at pages 332 to 338 regarding the Adult Protection Bill following the Enabling Access to Justice oral evidence session held on the 23rd of May. There's part of that, but I'm not clear that we've got time frames on, to be honest, in that response. I'm asking you to note the item for the correspondence to the Committee for Health and consider scheduling an oral evidence session with DOJ officials who are assisting with the legislation once the bill has been introduced.
When's the bill to be introduced?
Well, the Minister in that response indicates there's a couple of other bits and pieces to be signed off and then they're going to proceed with it. That's accurate enough, is it?
Mm-hmm.
Deirdre?
Probably links into this, but I think at some point in the future as well, even a joint evidence session with health in terms of looking at some of the issues which you're hearing consistently, in terms of those who end up in the justice system that really should be in health, and recognising obviously there's pressures in both systems, but whether there's a possibility in the autumn to do like a joint evidence session on that issue.
I think that's entirely necessary. The clerk has said to me that there's going to be a joint session on the right person, right care. I think some of this goes beyond, though, because I'm not sure that our health colleagues understand the extent to which, I'm not sure we understand fully, but we're hearing it more often, of the extent of the impact on justice, actually.
It's even keen on on the transformation bids. Could there be potentially criteria, that they're joint bids and actually not just in name, but actually the work that they're now, collaborating more in terms of resources, but then also in terms of tackling inequality that's presenting them. I don't know. Maybe that's work in progress in terms of the interim transformation board that's been set up. But are there further stipulations you can add to transformation bids coming forward on these issues? I don't know. So
this is what I've been trying to get at for months now, and we keep getting, we're doing this project and we're doing that project, and it's all stuff we know about. But strategically, I can't get my arms around what is actually happening in terms of collaboration. So, yeah. Item 16 then is an invitation from the Probation Board for Northern Ireland, and that's at pages 347 to 348. to a video launch and panel discussion event, which is to take place on Wednesday the 26th of June. Anyone who wishes to attend should respond to the email by Monday the 17th of June, and that address for response is contained in the invite. Content to note?
Noted, yeah.
Thank you. Item 18 is correspondence from the Northern Ireland Assembly's Head of IT at page 350 regarding constituency office survey for members. That's been extended to Friday the 14th of June. That's all I have. Everything else we're asking you to note. Is there anything else any of you want to raise? No? Chairperson's business. Deirdre, you've given us something of an overview about what happened at Magabry, but thank you for taking that forward on behalf of the committee to you and Ciara. Is there anything else that you want?
I think it was worthwhile to go and see it. We met the IMB at the start of the visit, and obviously we didn't get into maybe the more complex areas in terms of some of the cases. So I think if we were going to look at a future visit to maybe get in and see some of them, I think there's been some really good work around the community garden schemes and some of the programmes of work that are being done. But obviously there are big presenting challenges around people who are in isolation. Obviously the increased demand in the prisons as well, and then also the more complex cases in health in terms of rehabilitation. So maybe a focus in the autumn or getting into early next year in terms of looking at those issues would be useful. But I mean, it was a good visit, and again, yeah, thanks to the team that were there and the prisoners who, you know, came out and spoke to us and stuff in terms of the visit. It was good to go and see it, like, so, but keen to get in and see the other parts that we didn't see.
Yeah, like I'm keen to get in. In general, I'm keen to get in, and I was gutted to have missed it. But also, obviously, I indicated there about writing to Beverly to thank her for all the visits. But if we could also write to the officials who were involved in organising that particular visit. But I think there are issues there that we would want to take forward, and even in terms of what the prison officers are having to deal with. I mean, they're not qualified to deal with some of the things that they're facing, and they shouldn't be dealing with some of that stuff. It's not fair.
Well, I think they did say, sorry, is the levels of remand, and prison's not the right place for those who are remanded then, you know, in terms of mental health and substance use and stuff. So that is an issue, like in terms of feeding into the other conversation that we just had, that we do need to look at and drill down into a wee bit.
Yeah. So just again, another issue that arose in some of the prison visits is in relation to the care support that's required for a number of prisoners, which has been delivered by prison officers, whereas health would be providing that in the community. Health's providing its range of health provisions in the prison, and there, as I understand it, there is a dispute's maybe too strong a word, a lack of interpretation around how care should be delivered in prison by health and social services.
Yeah, there's no doubt there's an issue there. I mean, Tide Bank, where we're hearing of females in their 80s and so on, and personal care and showering, and that's all very difficult, I think, not the right setting. So all of those issues, I think, need to be considered, and jointly between us. It's a societal problem. Any other business? Anybody have anything? No? Well, sorry, Deirdre, you have something?
No, I was just going to confirm we're not, I'm assuming we're not meeting next week then, there's no...
Well, if there's not going to be a visit,
no,
then I think that we'll not. And then on the 27th, we've got the items that are scheduled there. If anything else that is important or an emergency or required arises, then we'll add that to the agenda, but we're not going to seek to pad it out.
No.
Is that our members members agreed to that? Yes. Thank you very much. So on that basis then, we will see you back here on Thursday the 27th of June at 2 p.m. Thank you very much, everybody.
Sure.
thank you.
Committee Room 30, Sound. Committee Room 30, Sound.